Mindenki szeretettel köszöntünk a Természetjog napjának a második napján, az idegen nyelvű napunkon. Ezt is úgy rendezzük meg, ahogy a tegnapi napot is, tehát rendkívüli körülmények között, online formában, és hát több résztvevővel, külföldi résztvevőkkel is, és a köszöntő után majd az angol nyelvre átváltva, ami nem jelenti azt, hogy minden adás angolul fog elhangzani. A természetjog napja mindig egy ünnepi nap, lépünk a hétköznapokból, a dolgokat a maguk természeti valóságában, normatív valóságában, maguk lényegében tekintjük. Azt hiszem, hogy ez egy időtárolásmód és teret áthidaló mindig ez a tudatosság, és ilyen a mi alkalmunk is, amikor több országból az időn átnyúlóan magukat a dolgokat tekintjük az ő valójukban, az ő értékükben, elveikben, normativitásukban, tehát mindig erről szólnak a természetjog napjai, amikor összegyűlnek a természetjogot legkülönbözőbb területen kutató tudósok, kutatók, professzorok, és számot adnak arra, hogy milyen kutatásokat folytatnak éppen ezen a területen. A mai alkalom következőképpen fog zajlani, Atya fog köszöntőt mondani, és utána kerül sor a rendhagyó online oklevél átadó ceremóniára, ami hát eléggé lesz, de azt hiszem, hogy a problémák nagyobbak a világban, mint hogy most akkor ezt problémának tekintsük, hogy most ezt online módon, virtuálisan kell megejteni. Akkor át is adnám a szót Kuminec Géza rektor úrnak.
Én akkor olaszul mondanám a mondókámat, jó lesz így?
Nagyon jó, köszönjük szépen.
Allora, buongiorno a tutti. All'inizio della nostra seduta, prima di tutto, saluto con distinto onore nel nostro cerchio il professore Andrea Padovani, all'occasione che possiamo dargli il titolo l'eccellente ricercatore del diritto naturale. Se mi permettete, dico qualche parola sul diritto naturale. Questa teoria filosofica del diritto dovrebbe essere molto accettabile, anzi accettato da parte dei cultori della filosofia del diritto, dai politici ed anche dai giuristi. E perché? Rispondo a questa domanda con le parole del professore domenicano Reginaldo Pizzorni. Cito: in generale possiamo affermare che tutti gli uomini, avendo un qualche discernimento tra il bene e il male, come tra il giusto e l'ingiusto, una inclinazione a operare il bene e una ripugnanza a fare il male, hanno anche una qualche idea del diritto naturale e dei diritti naturali dell'uomo come esigenza della retta ragione per la realizzazione autentica della persona, come legge costitutiva della persona, come un qualche ordine essenziale che è intimamente congiunto con la natura umana, o meglio con la persona umana, e che vale, o almeno dovrebbe valere, di per sé, indipendentemente dall'intervento del legislatore umano o dello Stato. Fine della citazione. Ma oggi i pregiudizi ideologici e la diffusione del relativismo rendono molto difficile la corretta comprensione di questa teoria. Ma sappiamo che la ricerca e la scoperta della verità o il riconoscimento e sequela di essa esigono dall'uomo veramente coraggio. La verità, infatti, si comporta come un imperativo categorico: solo me riconosci come la vera norma del tuo pensare, come vera norma del tuo agire, come vera norma del tuo sentimento. E si comportano proprio così i principi del diritto naturale. La teoria del diritto naturale, che è riconosciuta anche da parte della Chiesa Cattolica, è un medicamento efficace e forte per la malattia del relativismo, proprio perché dichiara autenticamente i diritti e degli obblighi fondamentali dell'uomo. Proprio questi diritti ed obblighi costituiscono le basi di ogni ordine giusto del diritto. cioè crea veramente giustizia e pace fra gli uomini, fra i popoli e fra gli stati. Dunque, i giuristi ed i cultori della filosofia del diritto devono lottare contro i pregiudizi ideologici ed il relativismo proprio con la diffusione della retta dottrina del diritto naturale. Per quanto riguarda i compiti dei giuristi e filosofi giustnaturalisti, ci dice più dettagliatamente la professoressa Laura Palazzani. Cito le sue parole. Il giurista non si può limitare a formulare norme registrando le istanze individuali e verificando il volere delle maggioranze. Il giurista è chiamato a difendere attraverso il diritto i valori intrinseci della giuridicità, i diritti fondamentali. È chiamato a difendere la giustizia contro l'ingiustizia nel diritto. E alla fine del mio breve discorso mi congratulo con il professore Andrea Padovani e saluto anche gli altri eccellenti ricercatori del diritto naturale. Auguro che arricchisca tutti noi la seduta scientifica che comincerà fra poco. Grazie della vostra attenzione.
Ringraziamo noi al nostro lettore della nostra università che ci ha introdotti proprio a nocciolo della questione cos'è sia il diritto naturale e cos'è la funzione che svolge nel nostro pensiero, nella nostra vita. And I think that it is the moment when I have to announce the decision of our award committee that has chosen for this year the person which is scholar of researcher of the natural law thinking, Professor Andrea Padovani, and this is the diploma, the dark blue velours front board with golden crest in the middle, and the internal part has the diploma, the motivation of it, and I try to share it on my screen. Yes. Okay, it's visible for everyone, I think. Okay, and I read the motivation in Italian, and I'm going to try to translate it in English. Diploma. Il centro di ricerca Ius Naturale della facoltà di giurisprudenza dell'Università Cattolica Paz Malpeter ha deciso di conferire al professor Andrea Padovani il diploma di riconoscimento di ricercatore eccellente del diritto naturale per aver svolto per tanti decenni, con risultati di rilevanza mondiale, ricerche in tema di diritto naturale medievale, con cui ha contribuito notevolmente alla conoscenza più profonda del pensiero cattolico di quell'epoca, rafforzando in tal modo la nostra identità di giuristi cattolici. E poi seguono le firme. Sì. This is a round of applause with the softly. A congratulation of heart. The motivation which why we have chosen and conferred this certificate of merit to Professor Padovani is the achievement findings in the research field of the natural law, especially in the medieval ages, which has contributed a lot thoroughly of our understanding, especially the 12th century, what was the soul of the lawyers, the jurisprudence, and is corroborated our identity to be Catholic lawyers. And congratulations for your effort, for your result, worldwide findings. And I think this is the moment when I have to cedere la parola, give the floor, but not the floor, but the screen and the microphone for you, for delivery your Lectio Magistralis, Professor Andrea Padovani. You have to switch the microphone. Accendere il microfono, per favore. Ancora? Unmuted? Muted. La sentiamo ancora? Ok, la sentiamo. Grazie.
Perfetto. Bene. Buongiorno a tutti. Il mio primo dovere è ringraziare il rettore e tutti i colleghi della Università Pasmani per l'importante riconoscimento che oggi mi conferite. È un onore per me del tutto inatteso. Con profonda gratitudine che ricevo questo importante premio. Devo inoltre scusarmi con voi per il ritardo nel contatto via internet. Purtroppo io appartengo a un'altra generazione, la generazione che molto ha studiato sui libri, sulla carta stampata, ma non è familiare con le tecniche moderne. Per fortuna mia moglie è una esperta informatica e questo ha reso possibile l'incontro di oggi. La mia Lectio Magistralis oggi affronta un tema, quello dell'insegnamento del diritto a Bologna, da Irnerio all'età di Dante, nel tentativo di evidenziare le linee fondamentali dell'esegesi, cioè dell'interpretazione del diritto. Non devo certamente ricordare a voi, egregi colleghi, l'importanza della riscoperta dei testi che compongono il Corpus Iuris di Giustiniano e come questi divennero l'oggetto di studio a Bologna a partire dalla fine dell'anno 1000 e dai primi del secolo XII. Soprattutto il digesto fu la scoperta fondamentale che avviò una nuova stagione della giurisprudenza europea, perché è vero che del codice, cioè della raccolta delle costituzioni imperiali promosse da Giustiniano, si aveva avuto qualche notizia in precedenza e lo stesso anche delle istituzioni o delle novelle costituzioni, le ultime costituzioni emanate da Giustiniano. Dico di questa parte del Corpus Iuris si era avuta qualche notizia, anche se trasmessa da codici ancora non criticamente trasmessi. La grande, fondamentale scoperta è quella, dunque, del digesto, cioè dei 50 libri nei quali l'imperatore Giustiniano aveva raccolto il tesoro della giurisprudenza romana. Si potrebbe dire che in questo modo, nella composizione del digesto, Giustiniano salva questa grande sapienza trasmessa dai romani, come in un'arca di Noè che si salva dal diluvio, non già delle acque, ma delle invasioni barbariche, che, come sappiamo, cancella le tracce della cultura e della civiltà romana. Non sappiamo dove e quando precisamente il digesto fu scoperto, probabilmente in un luogo vicino a Bologna, oppure tra Bologna e Ravenna. Ravenna, già capitale dei possedimenti bizantini in Italia, collegamento con Bisanzio, con Costantinopoli. Dicevo che il digesto in un certo momento, a un certo momento, finisce tra le mani di Irnerio, che allora viveva a Bologna insegnando le arti liberali, grammatica, retorica e dialettica. Di questo personaggio di Irnerio si è molto discusso a partire dai tempi del grande storico Fonsavigli, e ancora si discute fra gli studiosi tutt'oggi, perché alcuni ritengono che Irnerio sia una figura dai contorni storicamente non accertabili, oppure alcuni ritengono che in realtà Irnerio non abbia mai insegnato il diritto. Irnerio sarebbe in sostanza una invenzione dell'università bolognese per dare a se stesso lustro e onore. Non entrerò qui ovviamente su queste polemiche. Dal mio punto di vista esistono documenti attendibili, sicuri, che confermano il valore della tradizione, che assegna ad Irnerio l'inizio della Università di Bologna, ma soprattutto l'inizio di una nuova e approfondita ricerca sul diritto. Irnerio è autore di glosse segnate Y o I e fu maestro di allievi di grande valore. Ricorderò tra tutti Bulgaro, Martino, Jacopo, Ugo, i 4 dottori che si porranno come continuatori di Irnerio. Ma non è tutto. C'è un dato di grande importanza sul quale io voglio attirare la vostra attenzione. Irnerio, prima di diventare docente di diritto a Bologna, fu autore nella sua giovinezza di un testo teologico, il Liber Divinarum Sententiarum, che è stato edito da Giuseppe Mazzanti nel 1999, devo dire, dietro mia indicazione. Perché è importante la scoperta di un Irnerio che in origine è esperto di teologia. È importante perché non si possono capire, non si possono comprendere molte glosse di Irnerio senza comprendere che sullo sfondo c'è una raffinata competenza teologica. Noi studiosi moderni siamo ancora prigionieri di uno schematismo accademico che concentra lo sguardo soltanto su settori specifici, tecnici, ma questo non ci aiuta a capire il mondo, la cultura di questi antichi maestri che non conoscono queste separazioni, ma hanno uno sguardo ampio su tutto ciò che riguarda l'esperienza umana. La scoperta di un Irnerio teologo che si muove all'inizio nell'orbita del grande Lanfranco del Bec e poi di Anselmo d'Aosta è importante soprattutto per demolire un pregiudizio comunemente diffuso, che cioè la nascita dell'università si pone in contrasto con la Chiesa, che fino ad allora era stata custode, depositaria del sapere. Non è dunque così. Irnerio è la figura più evidente che una cultura religiosa sensibile alla Chiesa ha aiutato lo sviluppo delle università. Il seme gettato da Irnerio non è andato perduto, anzi Irnerio è l'erede di un mondo che, greco e romano, si è occupato del diritto naturale. Ma se noi troviamo anche alcuni accenni alla dottrina del diritto naturale negli scritti dei giuriconsulti romani raccolti nel Digesto, c'è una differenza importante, perché Irnerio e i suoi allievi danno un nuovo slancio speculativo, conferiscono una nuova profondità teoretica a ciò che era stato detto e scritto dai giuristi romani, che poca o nulla familiarità hanno con la filosofia. Il legame tra teologia e diritto, l'attenzione che Irnerio rivolge al diritto naturale come segno, come impronta della creazione divina, che è governata dal Logos. Non c'è bisogno qui di richiamare a voi il grandioso prologo del Vangelo di Giovanni. Dicevo, il seme gettato da Irnerio fruttifica per diversi decenni. Mi sono occupato di tutto ciò in un libro di diversi anni fa, Perché chiedi il mio nome? Dio, natura e diritto nel secolo XII. Dicevo, il tema del diritto naturale attrae l'attenzione di grandi continuatori dell'insegnamento di Irnerio. Penso a Piacentino, il quale scrive che il diritto naturale scaturisce, emerge dai misteriosi segni della natura, de occultis nature similibus. Con questo, orecchiando un insegnamento di un grande pensatore precedente, Giovanni Scoto Eriugena. Ma c'è tutto un filone di pensiero che è contemporaneo ad Irnerio o agli allievi di Irnerio. E noi lo cogliamo nella filosofia dei maestri di Chartres, i quali vedono tutta la creazione come il risultato non del caos, non della irrazionalità, ma di una ragione che è paragonabile a un canto, a una melodia. L'idea non è nuova, lo stesso Platone aveva parlato del nomos come di canto e di norma insieme. Lo stesso termine indica il canto, quello che si accompagna alla cetra, che è accompagnato dalla cetra secondo la bella immagine dei maestri di Chartres. Canto e nomos, e legge. Ed è un'idea che noi ritroviamo anche in Dante. Ricordo il mio vecchio professore di filosofia del diritto, Guido Fassò, che tanto aveva studiato la nozione del diritto naturale. Diceva questo mio vecchio maestro vedeva nella definizione di Dante ius hominis ad hominem proportio, la più bella delle definizioni del ius, del diritto. Perché? Perché nel momento in cui il diritto è proporzione, viene evocata l'idea dell'armonia, della bellezza, del canto. La bellezza, che è la suprema aspirazione nel cuore dell'uomo. Se c'è qualcosa di profondamente naturale, è la nostalgia della bellezza di cui noi siamo portatori. Ecco, una delle espressioni del diritto naturale, o forse l'espressione più alta del diritto naturale in noi. Non voglio insistere ancora su questi temi, ma devo dirvi che questo legame stretto tra filosofia e diritto, tra teologia e diritto, che caratterizza i primi decenni della scuola bolognese, poi viene a mancare già agli inizi del 1200, quando la personalità di grandi maestri come Giovanni Bassiano, come il suo allievo Azzone, come Accursio, che di Azzone è allievo, imporrà una concezione del diritto, una concezione del lavoro, dell'attività del giurista, che è ridotta ai suoi termini tecnici. Ci sono passi come quelli in cui Accursio dice non è necessario che il giurista conosca la teologia, evidentemente in polemica con quello che era accaduto fino ad allora. Non è necessario conoscere la teologia. L'unica cosa che importa, dice il suo maestro Azzone, è nel discorso giuridico allegare, proporre le leggi di Giustiniano. Sì, i maestri continuano ancora nel 200 a parlare di diritto naturale, ma manca il calore, lo slancio, la profondità di quei primi maestri. Guardate, questo è un fatto importante. La svolta verso il tecnicismo, verso la settorialità del sapere che si compie a Bologna nella prima metà del 1200. Ed è importante perché sappiamo benissimo quale profondo influsso abbia esercitato il magistero dei nostri doctores. Bologna conosce i nostri dottori, Giovanni Bassiano, lo ricordo, Azzone, Accursio. Questi, tramite i loro allievi, diffonderanno questa concezione del diritto, ormai slegata dallo slancio teologico-filosofico originario, lo diffonderanno per tutta l'Europa. Pensate alla fortuna, al successo della glossa accursiana, ovunque. Se questa è la linea vincente a Bologna, dicevo quella dei nostri dottori, c'è un'altra linea che al momento è isolata, quasi messa da parte, ma esiste. È la linea proposta da un altro grande maestro di nome Odofredo. Perché è importante Odofredo? Perché lui non propone più lo strumento, la tecnica della glossa che era stata usata da Irnerio fino ad Accursio. La glossa è una notazione proposta alle singole parole del testo di una legge. È come una serie di flash, se volete, no? Una serie di flash immobili. Odofredo invece ha un'altra visione, ispirata dalle nuove correnti logico-grammaticali che vengono dalla Francia principalmente, tendenze che si racchiudono nell'espressione logica modernorum, tanto studiata da un grande come De Reich. Bene, Odofredo cosa fa in sostanza? Odofredo studia le singole leggi nel loro ordine, illustra le singole leggi una dopo l'altra in un discorso lineare, esauriente, con un loro sviluppo autonomo, coerente, che non cede alla suggestione di questa o quella parola, ma obbedisce a un piano espositivo preordinato, razionalmente condotto in maniera conseguenziale. Cosa voglio dire con questo? Giusto per aiutarvi. L'intelligenza di quello che io dico. Odofredo ad ogni singola legge propone la ratio, il senso complessivo di quella norma. Ci sono due parole che lui premette all'esame delle singole leggi. Hoc dicit, dice questo. Insomma, da subito, Odofredo dice qual è, in sintesi, la causa finale della norma, il motivo per cui quella norma esiste, la sua funzione all'interno dell'ordinamento. E questo non esisteva nella glossa, semmai era compito dello studioso arrivare a questa composizione sintetica. Bene. La linea di Odofredo non ha successo subito a Bologna, avrà successo in Francia, perché Odofredo ha tra i propri allievi, tra i propri studenti, diversi francesi. E dalla Francia questo metodo, che è il metodo del commento, tornerà in Italia e a Bologna anche, per mezzo di un grande giurista che si chiama Cino da Pistoia, che è contemporaneo, amico, giurista e poeta insieme di Dante. Bene, cosa voglio dire? Non voglio protrarre il mio discorso. Se all'inizio il diritto con Irnerio e i suoi seguaci, il diritto si era saldato, si era collegato alla teologia e alla filosofia. Qui, a partire dalla seconda metà del 200, il diritto si lega alla logica e alla grammatica. Vedete com'è cambiato, come cambia l'orizzonte. Oggi, anzi, a partire da questo momento, la riflessione dei giuristi obbedisce ad un metodo rigoroso, fondato logicamente. Ciò che conta è non la verità intesa come corrispondente all'essere. La verità non viene più misurata sul piano ontologico, la verità viene misurata soltanto sulla base del linguaggio, della coerenza del linguaggio. Vi capite quanto questo nuovamente sia durato fino ad oggi? Questo approccio logico, analitico, lo ritroviamo già a Bologna. Bene. Al decadere dell'orizzonte metafisico, colpito dal trionfante nominalismo, si opporrà soltanto sul finire del 300, in un ultimo sforzo volto al recupero dell'eredità di San Tommaso, il grande Baldo degli Ubaldi. Muore nel 1400, ma saranno gli ultimi bagliori di di un medioevo ormai al tramonto. Grazie per la vostra attenzione.
Ringraziamo noi, professore, questo percorso nel XII-XIII secolo e ci ha fatto presente, ci ha convinto del fatto che quanto era importante quando era presente, c'era il contorno religioso, teologico o filosofico e quando non c'era e quali sono stati i motivi. Consiglio a tutti quanti a leggere il bellissimo libro Perché chiedi il mio nome? Dio, natura e diritto nel XII secolo. Anche quello scritto assieme e curato insieme con Peter Stein. Bellissimo, tutti e due i libri.
Anzi, se permetti, Janos, devo dire che quello che io vi ho detto ora nella Lexio verrà poi esposto in maniera più approfondita in un libro che già adesso è alle stampe e che verrà pubblicato in Italia dal Mulino, si chiama L'insegnamento del diritto a Bologna nell'università ai tempi di Dante.
Che bellissimo! È bellissimo.
A breve arriverà. Janos è una copia che vi spedirò per gratitudine.
Grazie, tanto già in anticipo non vediamo l'ora di avere nelle nostre mani. È da un professore di Bologna, sui professori più belli della giurisprudenza di Bologna. Grazie tanto e ci sarà un'intervista con lei la settimana prossima, come ha detto, un'intervista bilingue, italiano-ungherese. Ok, ringrazio tantissimo e ovviamente spediremo per via posta quello che abbiamo soltanto mostrato nella camera.
Janos, ti mando il mio indirizzo.
Ok, grazie. Grazie tanto.
Sono obbligato, grazie signor Rettore e buona giornata.
Ringraziamo a lei e congratulazioni di cuore.
Di nuovo.
You're muted, Janos.
Thanks. We can go ahead because we have two excellent researchers, scholars of the natural law, and the award committee in this year has chosen these two other scholars which have contributed in a huge way to an understanding of the natural law thinking. One is from the Roma law research field, and the other one from the philosophy of law. And first of all, I have to turn to the diploma of merit of excellence of Szilárd Tatai, and I show the internal part of the diploma in the camera, and I try to share it simultaneously from my it isn't right. Another attempt is going to be, yes, the right diploma, which is written, the motivation of why we have conferred this diploma of excellence to the professor Szilárd Tatai, because he has accomplished huge research on the field of the natural thinking, especially between the post-classical and pre-modern age. And we have already volumes written by him on this research field. Congratulations. And or not the floor, but the screen and the microphone is yours. Szilárd. Obviously, I hand over this diploma physically in person in the next days. A mikrofont légy szíves. Kapcsolni.
Sinan, you're still muted.
Sorry. Okay. I'm okay. It's funny when we are making classes, that doesn't cause a problem, but at the conference we are struggling with this. Thank you very much for this diploma. I'm not sure whether I have true merits for that or not, but at least I'm always trying to do that. Okay. As concerns today's topic, I decided to present a paper on Jean Bodin and his natural theory. Even if it is quite evident that he cannot have a solemn and great place in the big pantheon of the history of natural doctrines, but nevertheless he always refers to natural law. So that is a kind of apropos for me, because natural law and the history of natural doctrines is a kind of hobby horse for me. As for the title, it is intentionally anachronistic because, of course, it contains an allusion to Hobbes' Leviathan, and this seeming mistake is intentional on my part, because with the title itself, I want to show that maybe the greatest mistake that we can commit concerning Bodin is to read him in a retrospective manner from today's point of view, or from the perspective of John Austin, or maybe first of all from the perspective of Thomas Hobbes. And I think that if this perspective is dominating our side, that can lead to some serious mistakes, because that can produce a kind of false hope that we will meet in Bodin a completely modern theoretician, no matter how we conceive modernity. So we are expecting something else than the original Bodin. And this is one of the reasons why we are complaining about inconsistencies in Bodin, or partly this can be a reason for that. In 1930, there was published an article. I'm making allusion to that article only because of its title again. The title is Sovereignty at Crossroads. I think that's a perfect metaphor for Bodin, that he occupies a kind of intermediary position between the medieval limited monarch. I mean, his sovereign occupies a kind of intermediary position between the medieval limited monarch and the Hobbesian or Austinian ruler, who's really princeps legibus solutus. I think that another common misconception regarding Bodin is that, which is quite frequent in Bodin scholarship, that there is a great break between the first period of Bodin, when he wrote the Methodus et Facilem Historiarum Cognitionem, and on the other hand, we have the absolutist Bodin in the Les Livres de la République. One of the greatest Bodin scholars, Julian Franklin, for example, is influentially defending this thesis. Well, I think that as a matter of fact, there are changes in modern thought, which is quite usual in all thinkers. We have this, but I think it is much more a matter of changing changings in accents, details than in the essence. Most of all, the way of argumentation, the sources are changing between the two works of Bodin. For example, the important stylistic difference that writing the methods, he was mainly using the kind of literature that typically a Renaissance humanist thinker used. But later in the Republic, he more and more got used to late medieval Roman law literature, Barthes and most of all Baldus, the post-Grosseteste or commentator school. On the other hand, a priori, I have some problems with when we are trying to force this kind of bipolar distinctions between, for example, absolutist and constitutionalist. I think this is, in most cases, this is hindering us to understand things more than giving a help in cognition. A third typical commonplace already mentioned regarding Bodin is that he is always inconsistent in his theory. There are good arguments for this, I think, but we will see during the lecture how much and how serious inconsistencies are there. Very often it is cited that Bodin defines sovereignty as something absolute, and then we have a plethora of a great number of limitations. Or concerning his definition of law, he bases his definition of law on the legislator's will, but in the same sentence, he's referring to the frank and good will of the sovereign, which is naturally reminiscent of not a voluntarist, but a kind of rationalist point of view. Of course, there is some link between the two problems, optional contradictions. So what is then the place of natural importance? There can be different hypotheses. First, it can be said that it is not more than a simple rhetorical device against Machiavellianism. According to this interpretation, Bodin doesn't take really seriously natural law, but he wants to fight some kind of amoral view in politics. There is another interpretation which is saying that while natural law in Bodin is not more than a kind of good advice or prudential advice for princes, or maybe simple moralization. In a word, this is not law. This is some kind of morality or moralization. Or there's a third approach, critical approach, saying that, okay, from time to time, he's referring quite often to natural, but nowhere we find any systematic treatment of natural in Bodin. And we can ask whether, if there is really a natural law theory or doctrine, or some, at least in an embryonic form in Bodin, even though there is such a thing as natural law in Bodin, really, maybe it can be formulated against the whole question that I'm posing, that maybe it has not a relevance at all for his theory of sovereignty and his conception of the state. It doesn't really matter. For example, in solving the contradictions or apparent contradictions that we have in Boden's work. I'm hoping to be capable of demonstrating that to a great measure, the contradictions in Boden's theory of the state can be explained by his natural theory, and at least partly, or some of the contradictions can be even solved through this. So it has some kind of explanatory force to look after his natural theory. Now, first of all, it should be emphasized that Boden, like later Hobbes, is clearly and strictly differentiating between droit and loi, use and lex, right and law. He associates right with equity and law with command, more precisely with command of the sovereign power. Secondly, his theory is not typically a theory of natural right, droit naturel, but a theory of natural law, loi naturelle, and is quite an illustrative representation of his theory of a voluntarist theory of natural law. And in a sense, like it can be argued in many cases of voluntary theories, in a sense, for him, nature is a kind of positive law, because it is always an ordinance of an absolute lord. In general, law in Boden's view is a command of an absolute lord, either of the command of God or that of a sovereign, who can always change it whenever he wishes to do that. Let us see one of the best quotations which can be obtained from Boden, which can offer quite a clear definition of natural law in Boden. I take this quotation from the Methodus. Here, Boden is saying that, in English translation, so man may understand that God is bound by no number, by no necessity, but is released from the laws of nature, not by the Senate or by the people, but by himself alone. For since he himself ordains the laws of nature and has received dominion from no other than himself, it is fitting that he should be released from his laws, and at different times should make different decisions about the same things. So it is clear that natural is really the law for Boden, and we are speaking of a typical governmentalist conception of natural law, which is a manifestation of God's sovereign omnipotent will. It is interesting to note that he's making a parallel, as usually, by the way, between popular and divine regime. He's referring to Senate and popular consent, which God doesn't need in order to change the moral and natural order made by himself. Of course, that implies a conception of natural which allows changings in the moral order. What is the philosophical view behind this? As usually, the negative hero for Bodin is a kind of misconception of Aristotle. He's the target of his critics and the so-called necessitarianism of Aristotle, which is, as we know, to great measure can be attributed to some Arab commentators. But what is more interesting, that the main source of Bodin's criticism against Aristotle is not late medieval nominalism and Christian philosophy or theology, as we might maybe expect, but Maimonides and in general Jewish philosophy and theology. It is only very late in the Demonomanides Sorcier in 1580 that Bodin first refers to Duns Scotus, and it doesn't even make allusions to William of Ockham, which is quite interesting. And when he refers to Scotus, in many cases, in most cases, he doesn't mention at all Scotus' natural conception. Okay, this is one side of the coin. Other side of the coin, that still in Bodin we can find the traditional picture of the great chain of being, and it has an important place. From time to time, he reiterates this imaginary, and he's laying great emphasis on that point, that the great God of nature is arranging the world in a harmonious way. There is order in the universe, there's a cosmic harmony, and there's a hierarchy. We know very much this kind of imaginary and picture. So this is, and Bodin is repeating this picture in a very traditional manner and way. I don't see great differences from, for example, a typical medieval description of the great chain of being, and between that and that of Bodin. And that produces, of course, tension and dilemma for Bodin, because he wants to preserve order, and this kind of authoritarian view of morality and law is, of course, jeopardizing this kind of order, what Bodin wants to realize and to preserve. And here, the usual parallel between the omnipotent God and the sovereign is creating great trouble for Bodin, because if the sovereign is also absolute and omnipotent, then the preservation of order, the stability of the order it cannot be taken for granted at all, and it can lead, of course, to an arbitrary regime. It is a well-known fact that in Bodin's theory of sovereignty, the main function of the sovereign is legislation, lawmaking, and commanding in general contains in itself, in fact, any or other kind of functions too. So the word legislation, lawmaking, and commanding implies virtually anything in Bodinian terminology. So not only lawmaking, but also execution, judicial function, and so on and so on. In a typical modern fashion, Bodin is stressing that the sovereign is most of all a lawmaker and not a judge, as in the common medieval imaginary. So there is in him an evident shift from the passive to active rulership, a king, the creator, imitating God, not simply God's instrument to preserve God's order. So the main problem for Bodin is how to preserve order and how to hinder the abuse of the lawmaking power. As a matter of fact, Bodin himself interpreted his theory and his republic as a theory of a kind of limited monarchy. Maybe this is true, maybe not, but his intention was to produce a theory of a limited monarchy and kind of rule of law. We know that his definition of state contains the expression rightful government. And the legal solution, the interesting legal solution seems to be in Bodin that he's trying to find points of contact between jus naturale and positive law, jus civile. He even seems to conflate natural law with positive law. When he's referring to natural law, in most cases, he's in fact referring to Roman law, canon law, feudal law, or the law of nations. So we can say that why, on the one hand, he is quite positive weighting natural law, it's positive, God-made law. On the other hand, in a human perspective, when he's speaking of natural law, the notion of natural is getting close in his theory to positive law, in fact. But that point has an important consequence. The consequence that, on the other hand, Bodin is not only positive weighting natural law, but a bit just naturalizing positive law, or some core elements of positive law. He includes them to natural law, and this is important because that is a part of positive law which is defended this way by Bodin from authoritarian steps made by the sovereign, because that is saint that is the only territory of law which is saint for a sovereign, cannot touch it. And with this trickery, putting a label of natural law on some parts of positive law, he is proposing, suggesting sometimes even more constraints on royal power than the French literature of the previous century before Bodin. Another escape plan for Bodin is a theological way of argumentation. He's arguing that if the sovereign is a lieutenant of God, then it must share some more attributes of God himself. First of all, the sovereign should care for other people's welfare, and the sovereign must be just, fair, consistent, etc. And the main difference between a royal monarch and a tyrant lies in the fact whether he is respecting law or not. So evidently, Bodin seems to think that there is no real tension or contradiction between legal limitation and sovereignty. At least this is his view, no matter whether he is right or not, whether there's contradiction or not. But his intention was so. What and I arrive to the two final points. On which did Boden base his view? First, on legal practice. After his academic years in Toulouse, where he was humanist, he went to Paris and worked at the Parlement of Paris as an attorney, an advocate at court. And that day, French courts used a conception of kingly power as not legibus solutus, but legibus alligatus, a limited conception of limited monarchy, mainly in respect to proprietary rights, which will also play an important role in Boden's own theory. The other source can be a late medieval jurisprudence, most of all the commentators or post-glossators. Boden's preferred authority was that of Bardus. Also because Bardus was disposed to indulge in lofty philosophical arguments, and he was very keen on criticizing the Princeps Legibus Solutus view and place limitations on royal power. So paradoxically or not, but it is quite clear that Boden, by being a French theoretician of the state, clearly had a preference for the most Italicus against the most Gallicus, and in his late works he used much more extensively, as I see, the late medieval jurisprudence than the humanist legal theories. Okay, I'm very much sorry for being a bit too long and not respecting the time limits, and I'm really thanking for your attention.
Thank you for Szilárd, for giving allowing us to having insight over John Boden and how to not fall in the pitfall, trying to interpret the author from retrospective point of view, or cover the apparent or real contradictory aspects, and have key cornerstones how to interpret in a right, just way, not very easy text of our author. Thank you very much for your lecture. Okay, and my honor to announce you that the award committee, and on behalf of this committee, conferred in this year another diploma, certificate of merit of excellence to a scholar, to our colleagues, Professor of Roman law. It's very important to investigate the Roman law in the research field of the nature law thinking. And I am very pleased to announce that Professor János Erdődy has been found meritable to have this diploma. Unanimously was chosen, elected our professor, and the motivation is in English that he especially focused on the same topic on the rerum natura, the things of the nature of the things. It is a very, very important item Roman law thinking, and we have already volumes and several articles which demonstrated us that these findings were very, very important for a better understanding of the natural law thinking within the Roman law. And for that findings, our outstanding professor colleague Erdődy János deserved this certificate. And I give the floor for you. I try to share this diploma, this certificate, in order to every one of us could view over that. Yes, it is shown. Okay. And I give you the floor for your lecture entitled Claudianum and Levitas Animi, a gender issue. A very unusual title of paper of a scholar of Roman law. Please.
Yes, thank you very much, and thank you very much for the acknowledgement, for which I'm very grateful, and I feel really honored. First, I'm asking you whether I'm fully audible. Am I? Okay. Then I'm trying to share a screen because I've already prepared some PowerPoint slide to. Whoops, just a moment. And yes, okay. So the title of my presentation is Senatus Consultum Claudianum and Levitas Animi, a gender issue. And yes, as Professor Friwacki has mentioned, this is a somewhat say unusual topic, especially in a Catholic university, and especially in a natural law day workshop. Still, I think the circumstances amongst which I had rather the opportunity than the privilege to be confronted with also makes it or enables this topic to be dealt with. Probably some of you know that there is an annual worldwide conference of experts in ancient studies, which is called SIDA for short. This is the abbreviation for the French expression Société Internationale de l'Histoire des Droits de l'Antiquité. And so this is a worldwide conference of linguists, classical philologists, Roman lawyers, Romanists all together. And in 2019, this conference was held in Edinburgh, Scotland, where I had a contribution on Senatus Consultum Claudianum under the title Ancient Questions, Modern Answers. And so the point was that there are several questions in connection with this senatorial enactment in secondary literature, and I try to collect them, and with reflection to contemporary literature, I try to give some proper answers to questions already open for a while. And during the discussion, a Spanish colleague had an interesting contribution, but which was all the more, say, embarrassing, that he began his contribution with this sentence: Senatus consortium Claudianum, this was after all a gender issue. And this was all made me all the more perplexed, because this statement has nothing to do with his further contribution to the topic. So it was kind of, I think, or I deemed it as sort of a rumor control, that, okay, what my reaction might be. And I just tried to deflect the devil somehow, saying that it is safe to say that the Romans, should they have any, had surely a different sort of concept on gender as we now fashionably have. But this question still vexed me, so it didn't let me be, and I was just started thinking about the true concept of Roman approach, specifically with regard to Senatus Consortium Claudianum, because it is always interesting to see how the Romans themselves saw their own institutions. Plus, this topic is then related to the fact how women were considered in Rome in the society. And not first and foremost in law, because the legal stance of women is a mere reflection of how they were held in society. Okay, just sort of a recapitulation or revision. Senatus Consortium Claudianum, and in this slide, the question marks in brackets will be the references to the debated elements of secondary literature. So this senatorial enactment goes back to the 50s Anno Domini. Therefore, it is a motion of Emperor Claudius, and it sets out to punish with enslavement any free women who start or maintain a relationship whatsoever. So it could be marriage, cohabitation, or even a carnal sort of relationship, you name it. So who starts to maintain any sort of relationship with the slave of another, so the slaves of a different master, despite or contrary to the threefold protest of the slave's master. What are the sources, the primary sources we have on this topic? I would name three groups. The first one labeled literary sources. Amongst these, very important one is Tacitus, who is talking about a motion to the Senate, the aim of which was to penalize women who cohabited or even married slaves. So Tacitus is important for us because through him we can get to know the actual content of this Senatus Consortium. Then again, Suetonius is very important, all the more so because he's the one and only author to give a proper reason why this enactment was set in force. He claims that this is because of licentiousness and extravagance, libidinem, propter libidinem atque luxuriam. But also he contributes, or not contributes, but attributes this senatorial decree to Emperor Vespasian, which is deemed as a classical error in secondary literature. There is only one professor, I think from the Netherlands, Professor Sirks, who believes that there was to have been a renewal of this Claudian senatorial decree during the reign of Vespasian, and Suetonius had reference to this renewal of the text. But then again, we switch to the second group of sources, the legal sources, where amongst others, Gaius and his famous institutes is to be mentioned there. And this assertion is very important with regard to our topic as well. He he deals with Senatus Consortium Claudianum not primarily, so not as a legal institution, but rather in connection with other institutions such as Capitis Diminutio, enslavement, or even the status of children born from the relationship between a free woman and the slave of another. Then again, we have Paul with his Sententiarum Libri Quinque, where he gives an analytic approach. And the reason why Paul is especially important is that he is the only one to use the notion of denunciatio, this threefold protest or warning or denunciation of the slave's master, which may as well lead to the enslavement of the woman. And there are many other important sources such as Pliny, Tertullian, Ulpian even, or we can also mention the Theodosian Code or the Codex of Justinian, which are also contain important information, which all have important impact on this topic, but now they are marginal as for our specific topic. Now, when we switch to the issue of how women were regarded in Rome, first and foremost, we have to begin with some kind of terminological clarification. And at the top of this terminological clarification, there is a very famous text in the first book of Gaius's Institutes. This is fragment 144, where he claims that a tutor, so guardian, was attributed to women because of levitas animi, propter animi levitatem, the lightness of their souls, because of the lightness of their souls, so to speak. And now this, with other expressions which are very common in the sources, infirmitas sexus, imbecilitas sexus, or even fragilitas sexus, or sometimes fragilitas as such is used without any possessive, so as kind of a Hauptwort. So all these may as well lead to even the question that, okay, that women were second-rate citizens, or sort of something, so there was kind of differentiation between men and women on the basis of their comprehension or whatever. And what we see is that all these institutions, guardianship, tutela, cura, and even custodela, were formed during the application of jus civile, where it wasn't about social stance first and foremost, but about power and authority. So the point was to make order, and the question was how you make order. And via jus civile, you should order things, you should organize things, rather, just put them in order. In order to better understand the gradual change in terminology, we should take the linguist's coat on, even if it means that we only try to scratch the very surface of semantical approach. But if we consider infirmitas, or if we consider levitas as such, using mainly Thesaurus Linguae Latinae or Forcellinis Totius Latinitatis Lexicon, Oxford Latin Dictionary, and so on, we can see that there are two, say, using the very famous expression of this mass theory, there are two bushes, there are two groups of of notions. First, infirmitas is the first main expression, which is a synonym for imbecilitas, fragilitas, and it generally means a defectus firmitatis, or as a Greek counterparty, astheneia is the proper word. Levitas then means mobilitas and inconstantia. And when we see all the examples given by these renowned dictionaries, they're not necessarily related to women. None of these. Even the Oxford Latin Dictionary, which is the sole dictionary to cite this famous Gaius 144, only marginally mentions the reference to women under the third circle of meanings of levitas. So it is not say the mainstream connection between infirmitas, levitas, and women in Latin language, in ancient Latin language. Plus, there is a very famous, well, mostly famous for Romanists, debate between Ciro Solazzi and Joël Bocquin. As much as it could be regarded as a debate because they lived in two different eras, two different ages. Solazzi presented his very famous contribution to Infirmitas Aetatis and Sexus in 1930 in Archivio Giuridico, and this served as a preponderant approach of sources and really the mainstream, the communis opinio of this whole topic with regard to the stance of women and imbecilitas and infirmitas sexus. And Solazzi's point of view is based on interpolationenkritik, which means that he presupposes and tries to prove, let's add with success in the end, that all the texts in the Digest and the Codex of Justinians are mere post-classical glossae, nothing more, nothing less. And of course, this was sort of a preconception, and this is not that much hard to prove a preconception. Whereas at the end of the 70s, Joël Bocquin devoted a longer article only the semantics of the vocabulary of this whole topic, le vocabulaire de la faiblesse féminine dans les textes juridiques romains du 3e au 6e siècle. And there she concludes that the term infirmitas sexus was clearly used as a legal term in the sources well from the 3rd century Anno Domini, with a tendency of getting a more and more negative connotation. Okay, what are the primary sources of this whole issue of handling women, infirmitas sexus, negative connotation, and so on? First, Livy. In this source, Livy claims, talking about the ancestors, claims that it was due to the ancestors that no woman was allowed to administer their personal businesses without the cooperation of a guardian. Okay, if we go further, then we see Cicero. So in his speech pro Murena, for Murena, this is a very famous speech, and especially this part I'm going to take, nam cum per multa preclare legibus essent constituta. In this text, Cicero claims that there were many situations during Roman history which were excellently settled by laws. Yet, the way jurists interpreted, used these solutions given by law, these solutions became depraved, or even corrupted as a consequence. And he gives an ancient example of this, that women, propter infirmitatem consilii, because of the inferiority of their understanding, are always bound to rely on a guardian's authority. What is the basis of this, the first look communis opinio of primary sources? Cicero goes really back to Aristotle and his Politics, where Aristotle in this passage is talking about buleutikos, which is concilium in Latin, claiming that, okay, it is threefold. It comes into three parts or segments. As for slaves, this buleutikos is absent. As for women, they are without full authority. As the Greek term puts it, akouros, which is in connection with Latin kouros, curator, and so on. So it is interesting that we are talking about tutela with regard to women classically in Roman law, and even the attitude, the Greek attitude from which this whole concept stems from, talks about a curator actually. And for children, this buleutikos is undeveloped. Ateliers. Okay, then what are the conclusions? Because we see that there was a text by Cicero, and it goes back to a strong Aristotelian tradition. And it is especially true if we consider, for example, Cicero's own letters to his wife, Terentia, whom he deemed even himself as a lady who wears the pinches. So claiming on many occasions that, okay, you yourself can solve it, you can do it. Sort of attitude Cicero had vis-a-vis his wife Terentia. And still in public, he mentions infirmitas consilii with regard to women. So, and we also, if we had more time, I could add Quintilian and many other authors. This seems to be, or I think it's safe to say that this is sort of a rhetorical concept of having reference to ancient sources. Plus, guardianship over women has changed gradually during these 14 centuries of development of Roman law. On the one hand, we have the attitude given by the already seen Gaius fragment 144 in the first book, propter animi levitatem in tutelam esse. And then not far away from that fragment in the same book, we see that there is no real reason, or it is not reasonable to put under guardianship those women who are of age, who came or has come of age. So what we see is a gradual shift from the banner expression of officia virilia of the era of Law of the 12 Tables, to another passphrase, a very famous passphrase, social passphrase of the late Republican, early imperial era, which is ipsa sibi negotia tractare. So therefore, gender issue, even if we consider the 14th centuries of development, is a vast anachronism, to say the least. But what more we can add to this whole concept is the approach of phenomenology with this regard. And the one who dealt specifically with the stance of women, the education of women, is Edith Stein. And this is actually a work in progress, working with her works on Die Frau, or the woman, which was translated by the Carmelite community in Washington in 1996. It's still a work in progress for me, but what I feel is that the central theme is Wesensanschauung, the essence of givenness. And this essence of givenness as a translation is not only given by Freda Mary Oben, but also by David Crosby, who translated Reinach's Grundlage der Zivilrechts. So this means that we have to consider woman in her totality, as woman in her womanhood, individuality, humanity, and so on. So in all her aspects. This is, for me, for the first look, very familiar to the approach of Marc Aurèle, this Caraxian consideration of all things we just come across. As for conclusions concerning Senatus Consultum Claudianum, I could cite the very famous Max Caza, who is really and with merit, a sort of, say, sacred cow for Roman. It's sort of a fireplace from where we always start. When he claims that nach dem Senatus Consultum Claudianum wird die Bürgerin versklavt, die mit einem Sklave wider Willen seines Herrn, trotz dessen vielleicht dreimaliger Warnung, geschlechtlich verkehrt. So this is the approach most manuals contain concerning this senatorial decree. Yet, if we consider the primary sources, and we've seen Gaius amongst the first slides, Senatus Consultum Claudianum comes up with regard to enslavement, capitis diminutio, or status of children. There is no mention whatsoever of restrictions imposed on women with this regard. So a gender issue, addition to this as a vast anachronism, is also incomprehensible because it simply lacks Wesensanschauung. So it is nothing more, nothing less, but mere nominalism without considering the background. So we are just playing with the words, we're playing with the notions. Thank you for your kind attention.
Thank you very much for our second awardee, for Professor János, for having this insight. And I think that convinced us that we have to explore, investigate, scrutinize the primary sources in order to having a righteous understanding of the situation of the women. But reassured us that Senatus Consultum Claudianum and the Levitas Anima isn't the case of the gender issue.
Yes,
okay.
Definitely.
Thank you very much.
Thank you very much.
Okay, and for you. And we turn to the next presenter, and I am very, very pleased having with us the Franciscan friar, Professor Dominic Whitehouse, who are going to explain a lot about a person thinker which we are very little information about, such as was condemned by Pope 22nd with Meister Eckhart, but I am not going to continue at this point because I reveal my lack of knowledge in this research field. The screen and microphone is yours, Dominic Whitehouse, Professor.
Thank you very much. Screen.
No, the microphone is functioning, viewable and audible. Okay. Would you like to share some, but on the screen? Okay. Go. I think is everything all right?
everything seems to be, I can be heard, yes?
Yes.
The picture, share screen. No?
Yes. You have to select the right picture and share.
Share screen.
Share screen, yes.
No, share.
Okay.
No. Oh. No. No.
Yes, you have to select the right image.
Help, I can't. No picture. Nem tudom, hogy miért.
Ha beszélsz, működik.
Igen, de nem, nincs kép. Nincs kép.
Igen, nem kép.
Van, de van kép.
Vissza kéne.
Mit kell csinálni?
Most a professzor úr kiválasztott a képet, de nem a jót szerintem. Ez be kéne zárni, ezt a képet. Tehát unshare. Ugye van a piros gomb, fölül unshare. Tehát ugye, hogy stop sharing.
Stop share, jó.
Így működik.
De hol van, én nem látom.
Meg szeretné osztani a professzor úr a diáit,
a
szlájdjait?
Nem, köszönöm. Csak beszélek. Jó, vártam az én képemre. Jó.
Egyébként hadd mondjam reklámként, hogy én sokat gyóntam Dominik atyánál. Nagyon jó, ha ő beszél. Mindenféle értelemben. Szóval a legjobb gyónásom nála volt mindig.
Okay, I shall start here, and I apologize for my technical incompetence. Right. Mark Murphy, in his avowedly Thomist overview of the natural law tradition in ethics in the Stanford Encyclopedia of Philosophy, a very good article from a Thomist perspective, points out that Aquinas approaches this subject from two perspectives. From that of God's role as the providential giver of natural law, the transcendent perspective, and from the human being's role as the recipient of God's eternal law as natural law, the immanent perspective. From this latter angle, natural law, in Murphy's opinion, constitutes the preeminent part of Thomas's theory of practical rationality, in particular of ethical decision-making. But I think we can also say that virtually every important thinker of the later medieval age approached this subject by means of this twofold division. In the enormous, monumental James Joycean Summa that Olivi wrote approximately between the mid-1270s and the mid-1290s, the Languedocian Franciscan thinker, what we now call southern France, Petrus Johannes Olivi, links the two perspectives together as the joined questions 81 and 82 of Book 2 of this Summa. The first poses the question as to whether the human conscience is a single or multiple power, an act, or a habitus, that is, an ingrained or acquired pattern of behavior, thought, or action. And in the second, whether natural law denotes something co-created with the divine intellect, or rather the divine will, or both together. These two yoked questions are short and quite perfunctory, and need to be read in the light of two closely related issues that preoccupied Olivi during the 2 years or thereabouts that followed the Parisian condemnation of 7th of March 1277, in which the Bishop of Paris, Etienne Trompier, and his theological advisors censured 219 Averroistic and or Aristotelian propositions, and perhaps also Thomas Aquinas' also that they judged to be either contrary to the Christian faith or a threat to the morals of the students at the University of Paris. These two issues which preoccupied Olivi were the nature of the eternal ideas or exemplars by which God created the cosmos, which Olivi treats in question 6 of book 1 of his Summa, which is now can be read in Latin, it's available, and the preeminence of the higher will, rational will, in human acts of liberum arbitrium, that is, rational, primarily ethical decision-making, a subject which he treats most extensively, over 200 pages, in questions 57 and 58 of the second book of his Summa. In the short of necessity introductory talk, I have not got time to fill in background on Olivi, however interesting it might be. I will treat the radically voluntaristic character of Olivi's conception of natural law from the perspective of divine providence or beneficence. Olivi's theory of its role in human acts of ethical decision, I will have to put to the side, however important it is. At the close, I will make some comments upon the influence of Olivi's conception of natural law upon his English Franciscan philosophical successors, Duns Scotus and William of Ockham. At the opening of question 82 of book 2 of his Summa, which he devotes specifically to the various kinds of law, stretching from eternal law through received law, to natural law, to civil and political law, on which he wrote a great deal, perhaps the most important work of the medieval ages, on civil and economic law. Olivi makes clear his position regarding God's eternal law. In this talk, I'm going to concentrate on eternal and natural. Look at the scale. While law, these are Olivi's words at the opening of question 82, while law, by analogy, refers to many things, it principally refers, these are my translations, nevertheless, to the uncreated law, which is God. And this is, properly speaking, the will of God itself, the will itself of God, insofar as it prescribes deeds of virtue and prohibits acts of vice. However voluntaristic or voluntarist this might sound, Olivi makes little suggestion outside the important reservation, properly speaking, that the divine intellect plays a part in the uncreated, that is, eternal law, that is God, when placed in a 13th century Franciscan intellectual context, the proposition is unexceptional. And might I say, a lot of misunderstandings of both Duns Scotus and Ockham is because he is not put in a Franciscan intellectual perspective. As Lydia Schumacher demonstrates in her major study, Early Franciscan Theology Between Authority and Innovation, released in 219, very recently, the so-called divine command conception of natural law was already present in the first large-scale intellectual product of the Franciscan Studium Generale in Paris, the International School of Studies. In this case, the Parisian Studium was attached to and accredited by the University of Paris, which was established when the arts master Alexander of Hales joined the order in the early 1240s and transferred his seat at the arts faculty of the University Faculty of Theology of the University to the Parisian convent. This is called the Summa Haliensis, an extremely important summa. Schumacher argues that owing to the emphasis St. Francis of Assisi himself placed on a literal interpretation of what it meant to imitate the life of Christ, as reflected in the Gospels, and as subsequently stipulated in the Franciscan rule itself, and problematically his final testament, the early masters at the Parisian Studium Generale were already inclined to formulate a conception of natural law whose cornerstone was the faithful observance of divine commands. To their minds, these took two principal forms: those that God communicated to human beings in the Mosaic law, and then in perfected form in the law of the Gospels, namely natural law in the perfected guise of revealed scripture, and on the other, the law that God had written into human nature at the moment of its creation, that is natural law. That second point is crucial to the whole of Olivi's philosophy. Schumacher, however, insists against modern misconceptions that we should not view this theory as authoritarian, since the early Franciscan masters also emphasized that human beings were free to obey or disobey God's commands, whether communicated through human nature innately or through written scripture. Where Olivi breaks radically with his own Franciscan tradition is not in the preeminence that he gives to the divine will over the divine intellect as such, in God's infusion of his eternal law into human nature, natural law properly speaking, and also human history, natural law as more perfectly communicated in scripture. The early master, John of La Rochelle, who wrote the long tractate, very long and important tractate on law in the Summa Haliensis, and also an influential Summa on precepts and counsels, a work I don't think is readable in manuscript, that defined natural law as that by which anyone understands, any person understands, is conscious in themselves as to what is good and what is bad. That's relatively traditional. While this would seem to pertain primarily to reason, in my modification of Schumacher's words, since consciousness implies a habitus, since consciousness implies a habitus, an acquired or accrued way of behaving, acting, or thinking, which is generally called a habitus of the will, the application of the natural law is not simply an act of reason, but also a habitus of the will in Franciscan thought. In elaborating this contention, he writes that an act, Olivi, of reason, John, proceeds from, and this presupposes the substance of an innate operation. Thus, John unquestionably gives priority to the will, voluntas, and not the intellect in human applications of natural law, and by extension, I would suggest, God's infusion into the human sphere of his eternal law. So voluntarism is already there from the start of the Franciscan tradition. Now, what is radical about Olivi then, if it's not his emphasis on the divine will as the provider of natural law to human beings? Well, Olivi, however, does not simply give a relative priority to the will in respect to the intellect in God's communication of his eternal law to human beings, that is, a cooperative relation between the divine will and the divine intellect, where the former nevertheless has a primary role, but an absolute one. Absolute. In Olivi's theory, the intellect plays only a passive role in God's providential impartment of his eternal law. In Aristotelian ontological terms, it acts as the matter which the will informs. In causalogical terms, it is the preeminent cause necessary for the will's sufficient act. While Olivi certainly hints at this absolute preeminence of the divine will in question 82, he explicitly argues his case in the long and complex question 6 of Book 1 of his Summa. where he rejects not only Aquinas' position in regard to the eternal ideas that God holds in his intellect, but also, and this got him into quite a bit of trouble, Bonaventura's temperate cooperative voluntarism. So he rejects both Aquinas' Aristotelianism and his own milder form of Franciscan voluntarism. In that question, this is question 6 of book 1, Olivi, thankfully, provides a formulaic summary of his argument. And this is what Olivi says. And he looks at the matter from the perspective, medieval perspective of Aristotelian, of essence and existence. In effect, although the divine intellect, crucial for Olivi, viewed according to our way of understanding it, from a human perspective, precedes the divine will as far as the quiddities or essences of objects taken independently of their actual state of being is concerned. This is Olivi as quasi-phenomenologist. Nevertheless, the divine intellect comes after the divine will, as far as the apprehension of the actual existence of things is concerned. Duns Scotus, Akitas, already in Olivi. From Olivi's quasi-phenomenological perspective, the individual existence that God, through his will, brings into being takes absolute precedence over the abstraction of the eternal ideas residing in the mind of God. Only relatively late in the 20th century have scholars recognized how indebted both Duns Scotus and William of Ockham were to Olivi's thought. This was not plagiarism on the two English Franciscans' part, although late medieval thinkers did indulge in plagiarism. Okay. Olivi is different, actually. Most interesting figure. They did not mention Olivi's name, did not say Olivi says that, but I don't think, the reason they didn't is for fear of censure from their own order. They were simply unable to name their source. Even as late as the 16th century, Franciscans had to ask permission from the Guardian to read Olivi's works, even though St. John of Capistran and Bernardine of Siena quoted Olivi verbatim in their sermons, and John of Capistran carried Olivi around in his luggage wherever he went. Paradoxes of the Franciscan order, of which there are many. For example, the theory of the contingency of the will's power of liberum arbitrium with its determined act, okay, when we choose, once in the moment it's done, so was believed to have been uniquely a product of Scotus's philosophical genius. However, Olivi had already expounded the theory in considerable detail in his own Bonaventurian way in question 57 of the second book of his Summa. While Duns Scotus, as far as the eternal ideas are concerned, backed somewhat from the radicality of Olivi's position, Ockham's own views resemble strikingly those of his Landochian predecessor, who he certainly read. While scholars previously might have suspected that this is the case or was the case, we now have sufficient textual and historical evidence to assert that Olivi profoundly influenced the thought of his English Franciscan successors with regard to the relationship between God's eternal law and its embodiment as natural law. Thank you very much.
Thank you very much for this amazing lecture, delightful lecture, because I was convinced that Petrus Johannes Olivi is crucial, not just understanding better Duns Scotus and William of Ockham, but it is very complicated figure, and it is worthy to study deeper. And we knew very little about him. Thank you very much for your very important contribution to this.
Could I just make one content reference for those more interested in matters of civil law? The crucial work of Olivier on contracts has been published in an excellent translation in French, and it's also now in English in a translation supervised by Sylvain Piron. Yeah? Also the very important, which is available in Latin and French, Quid Pronatius, crucial document. Thank you.
Yes, so we not forget to mention that Professor Whitehouse wrote his doctoral thesis especially about Petrus Johannes Olivi, that you have a very large knowledge and resources about this very important figure. Thank you very much.
Pleasure.
Okay, and the next speaker is Ákos Tussai. His lecture entitled Architects of Tarentum and the Nomos Physis Antithesis. Okay, go ahead. The floor is yours.
Thank you very much. I'm just going to share my screen. Okay, do you see my paper? Okay, thank you.
Yes, we do.
So the title of my presentation is Architects of Tarentum and the Nomos Physis Antithesis. The antithetical application of these two terms, nomos and physis, became increasingly prominent from the 5th century, and the validity of certain conventional beliefs about the physical world started to get questioned and eventually rejected. The impact of these scientific discoveries was nevertheless not confined to natural philosophy, but exerted considerable influence on moral and political thinking as well. As a result of the gradual decadence of traditional values and conventional morality witnessed in the second half of the 5th century, many thinkers endeavored to substitute justice with one's own interest as the ultimate rationale of human conduct. Though almost all extant sources of this antithetical views are vividly linked to the crisis of the Athenian democracy, the underlying phenomenon was nonetheless definitely not some Athenian peculiarity. In this paper, I consider a somewhat different formulation through Archytas's solution for the ethico-political dilemmas raised by Nomos Physis problem. Central to this discussion is a debate between Archytas and the Syracusan Hellenist Polyarchus, which came to us through Athenaeus's and Cicero's paraphrases of Aristoxenus's 4th century life of Archytas. These testimonia are to demonstrate that Archytas was deeply concerned with the Nomos Physis antithesis in general, and the rationale for nomoi and the goodness of lower bindings in particular, and they attest both his firm preference for rational deliberation and his utter contempt for the unbridled satisfaction of climactic desires. Although in his extant works, Archytas does never exploit the Nomos Physis antithesis, in a fragment of Aristoxenus's Life of Archytas, preserved in Athenaeus's Sophists at Dinner, we are told that he was certainly confronted with the problem regardless. According to Aristoxenus's anecdote, ambassadors from Dionysius the Younger came to Tarentum. Among them was Polyarchus, nicknamed the Voluptuary, man most zealous about bodily pleasures. Since Polyarchus was familiar with Arhytas and not a complete stranger to philosophy, he presented himself at the sacred presence, walked about with Arhytas and his followers, and listened to their discourse. Once the question for discussion and investigation concerned the appetites and in general the bodily pleasures, Polyarchus decided to interrupt the discourse by presenting the views of his own. It has often before appeared to me, gentlemen, as I examined the matter, that the contrivance of these virtues is quite absurd and far removed from nature. For nature, whenever it speaks with its own voice, commands us to follow pleasures and says that this is the course of a sensible man. But to resist and enslave the appetites belongs neither to one who is intelligent, nor to one who is fortunate, nor to one who understands the constitution of human nature. A strong sign of this is the fact that all men, whenever they lay hold of power that has sufficient magnitude, are carried towards bodily pleasures and think that this is the goal of their power, and to speak plainly, put pretty much everything else in a subordinate position. But the lawgivers, wishing that human beings be reduced to one level and that no individual citizen live in luxury, have caused the class of virtues to rear its head. And they wrote laws about our dealings with one another and about as many other things as seemed to be necessary for political union, and in particular about dress and the rest of our lifestyle, so that it would be uniform. Therefore, since the lawgivers were at war with the clan of those who wanted more than their share, first the praise of justice was magnified, and I suppose that some poets spoke of the golden face of justice, and again of the golden eye of justice, and then even the very name of justice was deified, so that altars and sacrifices to justice appeared among some peoples. After this, temperance and self-control joined the reveal and gave the name of greed to any preeminence in enjoyment, so that it is the one who is obedient to the laws and the voice of the multitude that is moderate in bodily pleasures. Since there is no reason to doubt that what Athenaeus presents here is from Aristoxenus' Life of Arhytas, in fact has its origin there, and generally speaking, Aristoxenus appears to be a fairly reliable source in Arhytas, I must conclude with Karl Hofmann that it seems most likely that what Aristoxenus presents is based on an oral tradition of a meeting between Polyarchus and Arhytas. However, the fact that there is simply no evidence for the existence of a Polyarchus matching Aristoxenus' criteria, and that there is some overlapping between the positions of Polyarchus and the Gorgias Callicles, are puzzling to say the least. Nevertheless, in light of what is known of Arhytas, the contention that the main lines of the story are historically authentic is, in my opinion, sufficiently amplified. The meeting is set in the reign of Dionysius the Younger, in which time Arhytas was certainly still amongst living. Moreover, the Platonic seventh letter attests that between Plautus II and his disastrous third visit to Syracuse, Arhytas and his Tarentine friends maintained friendly relations with the Syracusan tyrant. Arhytas is said to have visited Dionysius, and in a letter to Plato, he praised Dionysius' philosophical accomplishments, urging Plato to return to Sicily, lest their friendship, no small political importance, might get utterly dissolved. The seventh letter suggests, therefore, that this friendship was at least in part concerned with philosophy. Whether this philosophy was Arhytan or something else is impossible to tell. Nonetheless, the courtiers of Dionysius the Younger were certainly familiar with Arhytas and his philosophy. Thus, if Polyarchus was, in fact, the courtier of Dionysius, he was likely to get acquainted with Arhytas and given the 7th letter's description of the Sicilian Dios Eudaimon, his defense of hedonism is precisely what is expected of some Sicilian not properly cultivated in philosophy. What is more, this circumstance could also well account for the brevity and simplicity of Polyarchus's position and the lack of those minutely elaborated details that otherwise characterize Callicles' argument in Plato's Gorgias. Hence, while it is plausible enough that Aristoxenus was familiar with Plato's Gorgias in public, there is no indication that he composed the speech of Polyarchus with those facts in front of him or prominently in his mind. Perhaps the strongest evidence for Polyarchus's independence of Plato is that, unlike Callicles and Thrasymachus, Polyarchus does nowhere call justice the advantage of the stronger or another's good. Finally, since Polyarchus's speech is set some 20 years after the traditional date of composition of Plato's Gorgias, it is also difficult to see Aristoxenus' anecdote as the original on which Plato's portrayal of Callicles is drawn, which quite takes away the usual rationale for supposed fabrication. Unfortunately, neither Athenaeus nor other surviving sources did, according to the best of our information, preserve the section of Aristoxenus' Life of Aretas containing Aretas' response to Polyarchus' speech. Nevertheless, there is good reason to believe that one of its abridged paraphrases survives in Cicero's translation in his De Senectute. There Cicero presents an ancient discourse of Aretas of Tarentum, which was allegedly handed down to Cato, since as a young man he was with Quintus Maximus at Tarentum. Accordingly, Aretas used to say that no more deadly curse had been given to man by nature than bodily pleasures, since eager for this pleasure, our lusts spur themselves on blindly and without restraint to possess it. From this source are born betrayal of the fatherland, from this the overthrow of the state, from this secret conversation with the enemy. To sum up, there is no crime, no evil deed which the lust for pleasure does not drive us to undertake. Debauchery, indeed, and adultery and all such shameful behavior are aroused by no other allurements than those of pleasure. And although nothing more excellent has been given to man than intellect, whether it be by nature or by some god, there is nothing so opposed to this divine benefaction and gift than pleasure. For neither is there a place for self-control where lust is mastered, nor is virtue able to gain any foothold under the tyranny of pleasure. In order to make this better understood, he used to tell people to picture someone spurred on by the greatest bodily pleasure that can be perceived. He was of the opinion that no one would have any doubt that so long as he was enjoying himself in this way, he would not be able to think about anything, to achieve anything by calculation, anything by deliberation. Wherefore, nothing is so detestable and so pernicious as pleasure, since indeed it, when intense and prolonged, extinguishes all the light of the soul. Nearchus of Tarentum, my host, who had preserved in his friendship to the Roman people, said that he had heard from his elders that Aretas said these things in the presence of Gaius Pontius Samnit, the father of that one by whom the consuls Spurius Postumius and Titus Veturius were defeated in the battle of the Caudian Forks. Indeed, it said that Plato, the Athenian, had been present at the conversation, whom I discovered to have come to Tarentum in the consulship Lucius Camillus and Appius Claudius. Albeit most scholars assume that Cicero's presentation is loosely based on Aristoxenus, And there are also considerable evidences suggesting that Cicero had some knowledge of Aristoxenus' work in general and his life of Archytas in particular. The average text simply does not pretend to establish any connections with Aristoxenus. Quite on the contrary, Cicero perpetually alludes to a Tarentine oral tradition as Cato's source of information. However, despite of its nuanced details, Cicero's comprehensive pedigree for this tradition is most likely his own invention, designed to explain how Cato had access to Archytas' speech, because in Cicero's opinion, to assert that Cato had knowledge of speech from his readings of a second-tier peripatetic, such as Aristoxenus, would make Cato out to be more of a scholar of Greek philosophy than his Roman audience would be willing to accept. At any rate, Cicero's account of Archytas' speech squares nicely with the accessible information on Archytas' moral philosophy, and it seems to reflect in some eulogy of bodily pleasures. Since Aristoxenus certainly implied Archytas' response in his Life of Archytas, it is far simpler to assume that Cicero is drawing on this speech than to arbitrarily posit an otherwise untested second speech by Archytas in pleasure from which Cicero draws. Hence, Cicero's average testimony is likely to have its origin either in Aristoxenus' Life of Archytas or some other source heavily relying on the same. The central theme of Archytas' speech is that virtue and self-control are not unnatural to man, as Polyarchus wanted us to believe, but necessary preconditions of a rationally organized living. Thus, his problem with bodily pleasures is precisely that man's lust for the enjoyment of unrestrained pleasures hinders the normal course of reasoning and makes any agent spurred on by intense pleasures incapable of rational calculation. Though there are minor similarities with Cicero's presentation and Plato's early works on pleasure, the Archytan origin of Cicero's testimony is well attested by a wide range of textual evidences. First and foremost, in a genuine frame, Archytas identified numerical calculation as a precondition for human society, since as a direct opposite to onexia, logismos is said to promote like-mindedness and equality amongst fellow citizens. Once calculation was discovered, it stopped discord and increased concord. For people do not want more than their share, and equality exists once this has come into being. For by means of calculation, we will seek reconciliation in our dealings with others. Through this, then, the poor receive from the powerful, and the wealthy give to the needy, both in the confidence that they will have what is fair on account of this. It serves as a standard and a hindrance to the unjust. It stops those who know how to calculate before they commit injustice, persuading them that they will not be able to go undetected whenever they appeal to it. It hinders those who do not know how to calculate from committing injustice, having revealed them as unjust by means of it. From a doctrinal point of view, fragment 3 clearly serves as the counterpart of Polyarchus' position, for while in Polyarchus' account, the lawgivers wanted to level society and wrote laws about our mutual dealings, that our conditions be equal, and hence they waged war against the clan of those who wanted more. In Archytas' opinion, society is established by the realization of numerical calculation, by which panexia is subdued and proportional equality is brought about. In short, numerical calculation, a specific mental exercise, is the key both to one's mastery over planectic desires and the community's ability to maintain homonoia. The second evidence for the Arhitan origin of Cicero's presentation is provided by a set of genuine testimonies, ultimately deriving from Aristoxenus' on the Pythagorean way of life. According to Aristoxenus' anecdote, Sphinterus often told the story about Aretas of Tarentum, that when he arrived at his farm after some time, having recently come from a campaign, which the city mounted against the Sapiens, he saw that his steward and the other slaves had not given proper care to the farming, but had shown very extreme negligence. Although he was angry, vexed, in the way that he could be, he said, as it seems, to the slaves, that they were lucky that he was angry with them. For if this had not happened, they would never have gone unpunished when they had committed such great wrongs. This anecdote evidently illustrates that in line with the Pythagorean precept on temperance, Aretas himself refused to punish his servants in anger, because in his anger his capacity for rational thought was clearly hindered. And third, so Aristotle did not identify his source. It is possible to see his report in the Nicomachean Ethics and some predecessors' argument against the goodness of pleasure as a reference to Aretas. Accordingly, Aristotle recalls some saying that pleasure is not good because it is a hindrance to thought, and the more so, the more one delights in them. For example, in sexual pleasure, for no one could think of anything while absorbed in this. After all, I believe it has been amply demonstrated that Aretas certainly engaged in philosophical discussions over nomos physis and thesis in general, and the rational nomoi and the goodness of law-abidingness in particular. What little is preserved of his thought firmly attests both his preference for rational deliberation and his utter contempt for the unbridled satisfaction of climactic desires. Thank you very much for your attention.
Thank you for you, Ákos. It was a very important contribution to understanding better the atmosphere which surrounded Plato and others, and tyranny and nature of tyranny, and etc., etc., etc. Okay, we have a very brief lunch break because 12 and 50 is 10 to 1. We're going to gather with András Koltai, Rector of the University of Public Service, and they're going to take place the book launch of very important book entitled Christianity and Human Rights. Okay. And sharp, we're going to return sharp 10 to 1. Okay, bye. Hello everyone. We going to continue with the second session, and before we have a event because I am very pleased to have the possibility to announce that a very important book is already or half published, because in the press format is already available. This book entitled Christianity and Human Rights, and this book wasn't just invented by the same rector of the University of Public Service, by Professor Koltai András, but I have the proofs that every single phase of the redaction, editing, paging, send out the draft versions were made by director. The roof is yours, Professor András Koltai, Director of the University of Public Service.
Yeah, thank you very much, János, for this kind invitation. I'm very honored and also very excited about having this chance to talk a little bit on our joint project. János wrote the longest chapter in the book, as usual, in his case. But I think the book can have a wider appeal. Obviously, I just put the link of the web store into the chat. I'm not sure whether you can access it or not. Yeah. So as János said, the book is already available as an ebook and is currently is in press, so it will come out in hard copies in a couple of weeks. The title is Christianity and Human Rights. One may ask what was the motivation behind compiling this book. There are always books compiled in this subject. So in the last 3 decades in Hungary, we can name a few books mainly published in Hungarian. And that happened with the papers to be published in the book as well. The first time they were published, it was in a law journal of the University of Public Service. And after reading the submissions, I realized that the book can have a wider appeal. The book can, the chapters, if they are available in English, if they are accessible, can be an important addition to the debates that are really happening around us in Europe or all around in the Western world. Christianity and individual rights, or we can call them liberal rights, are both the pillars of Europe as we think. As we try to name these pillars, but the question is always there whether they are mutually exclusive or are they reconcilable. It's a truism that there are serious overlaps between liberal rights, liberal values, and Christian values. It's a truism, is a well-known fact for all the participants of this prestigious event. But if you follow the debates in Europe, I think it's not a truism, it's not a well-known fact generally in the public sphere. Hungary is a neutral country religiously, constitutionally. It is a great achievement of the political regime change, happened more than 3 decades ago now. And obviously we respect that constitutional value. A constitutional state in Europe should be religiously neutral, but this does not mean that the traditions of a country, of a culture, needs to be erased from history. Our traditions, our history, our values are deeply rooted in Christianity, so we need to find a balance between our past, between our traditional values and his commitment of religious neutrality. A state as such cannot be value neutral, and people acting on behalf of the state should make value-laden decisions every day, lots of decisions, and the value behind these decisions, or the foundations behind this decision, is can be or deeply influenced by Christian values. These debates can be very harsh. The clash between the liberal values and Christian values, not only in Hungary, but all around Europe. Just remember what happened in 2004 in the preamble debate of the Constitutional Treaty of the European Union, or just try to read through the relevant jurisprudence of the European Court of Human Rights, how they answer the question whether religions have a place in the public life or not. And the debates are present in Hungary, not only recently, not only in the last decade, but from the starting point of the rebuilding of the constitutional state 3 decades ago. We have a very strong reference to Christianity in the fundamental law of Hungary. We have fixed notions of marriage and family, fixed in legislative acts, in pieces of legislations, and the government and the constitutional legal system handles gender issues in a different way as they do in Western European countries. So we can detect some highly debated and topical issues, and the 16 essays collected in the book give some overview and some aspect of these highly debated issues. The 16 chapters were written by 16 different authors, all Hungarians. So the subtitle of the book is Hungarian Perspectives. We don't want to speak on behalf of the whole Europe or the whole Western world, obviously. But the book itself is very diverse in terms of the different fields of humanities that are present in the book: philosophy, political philosophy, jurisprudence, constitutional law, mainly. Some of the chapters have a general scope, general approach, while others deal with very specific issues such as marriage, family, or even the Bavarian crucifix case. So I think everyone can find something that is in his or her interest. The authors are not representative in some ways, not even in Hungary, because they all answer the preliminary question in the affirmative, which means that they all think that liberal rights and Christian values are not mutually exclusive, so they are reconcilable values and reconcilable ways of life people can choose from. So I just want to ask you to go through the pages of the book, and I can offer you for the distinguished contributors of this event complimentary copies of the hard copy once it comes out of the press. So if I can receive your postal addresses from János or from the organizers of the conference, I will post you a copy. I hope you will find it interesting, and I wish you a successful event for the afternoon. And thank you very much for inviting me here.
Thank you very much for you, and congratulations for the idea. We appreciate a lot the idea that your effort made for publish this book, and our research group is to promote this book. First of all, okay, thank you very much. I give the chair role for Zoltán Zurgányi.
Thank you very much. Adesso cambio l'italiano piuttosto perché il relatore prossimo sarà un professore italiano, naturalmente, ma poi naturalmente di nuovo parlerò in inglese se vi piace così. Allora, carissimi colleghi, il relatore della nostra sessione di pomeriggio, il professore Tommaso Scandroglio. Il titolo della sua relazione è Legge ingiusta e male minore, il voto a favore di una legge ingiusta, limitare i danni. Prego, signor professore.
Bene, io ringrazio innanzitutto per il graditissimo invito. Mi scuso se la mia relazione sarà in italiano, tenterò di parlare lentamente così magari qualcosa si afferra, insomma. Dunque, l'oggetto della relazione, della presente relazione, sarà quello di risolvere un quesito di etica applicata. Come voi sapete, con questa espressione etica applicata si intende una declinazione particolare, in un caso particolare, dei principi generali della morale naturale. Il quesito che andremo ad affrontare non è un mero, risolvere questo quesito non è un mero esercizio intellettualistico, ma in realtà quello è il problema di votare a favore di una legge ingiusta per evitarne un'altra più ingiusta, è un dilemma molto pratico che hanno dovuto affrontare molti parlamentari politici cattolici in giro per il mondo. Perché parlamentari politici cattolici? Perché questo aspetto, questo problema di etica applicata, il voto a una legge ingiusta per evitarne una più ingiusta, è stato un quesito, un tema che è stato indagato esclusivamente, quasi esclusivamente, in ambito cattolico. Questo perché c'è il problema dei mala in sé, delle azioni intrinsecamente malvagie. Invece per i politici parlamentari che si ispiravano a ideologie o a tesi proporzionaliste e utilitariste, ovviamente il problema non si poneva neanche. Questo quesito è stato poi affrontato anche nel numero 73 dell'Evangelium Vitae, enciclica di Giovanni Paolo II, un numero dedicato quasi esclusivamente a questa tematica. Questa tematica poi ho dedicato un'intera monografia che appunto si chiama Legge ingiusta e male minore. Affrontiamo ora quindi il quesito. Il quesito si può esplicitare nel seguente modo. Se sia moralmente accettabile il voto a favore di una legge ingiusta per limitare i danni. Che cosa vuol dire questa espressione per limitare i danni? Dentro questa espressione per limitare i danni ci sono molte ipotesi, varie fattispecie differenti. Ne indicherò qualcuno. Ad esempio, il quesito si può tradurre in questo modo. Se sia moralmente accettabile il voto a favore di una legge ingiusta per cancellare o diminuire la portata nociva, lesiva di una legge più ingiusta già vigente, qualora sia impossibile semplicemente abrogare questa legge già vigente o sostituirla con una legge giusta. Quindi stato di necessità. Che cosa vuol dire? Vuol dire che per abrogare la legge più ingiusta già vigente non posso che votare una legge meno ingiusta. Quindi questo, diciamo, è la prima declinazione di questo quesito. Facciamo un esempio. Io voto una legge che permette di abortire fino al 90° giorno e in tal modo vado ad abrogare e sostituire l'attuale vigente normativa che permette l'aborto sempre, anche dopo il 90° giorno. Il quesito di natura etica è questo, cioè è lecito votare questa legge meno ingiusta per evitare appunto che la legge più ingiusta continui a essere vigente? Secondo caso, seconda fattispecie, se sia moralmente accettabile il voto a favore di una legge ingiusta per cancellare o diminuire la portata lesiva di una legge più ingiusta che non è già vigente, ma una legge che sta per essere approvata dal Parlamento o che deve essere approvata molto in là, in futuro, in Parlamento, qualora sia impossibile impedire che venga presentata o approvata in Parlamento, sempre stato di necessità. Quindi nel primo caso io voto una legge meno ingiusta per abrogare una legge più ingiusta già vigente. Nel secondo caso invece io voto una legge meno ingiusta per evitare il varo di una legge che invece è ai lavori del Parlamento. Facciamo anche in questo caso un esempio. Voto a favore di una legge che legittima le coppie di fatto etero-omosessuali che siano, per scongiurare in futuro il varo di una legge sui matrimoni gay, che è una legge che può essere in discussione in Parlamento. Passiamo a un terzo caso. Voto una legge ingiusta per cancellare o diminuire la portata nociva di una sentenza giurisprudenziale ingiusta. Quindi nei primi due casi il male da evitare, il male maggiore da evitare era era rappresentato da una legge. In questo caso invece una sentenza. Anche in questo caso devo versare in stato di necessità. Quindi voto questa legge per abrogare, per eliminare una sentenza giurisprudenziale ingiusta, qualora sia impossibile annullare completamente l'efficacia giuridica di questa decisione giurisprudenziale, di questa sentenza, per il tramite di o atti giurisprudenziali, quindi in questo caso vuol dire che la sentenza è irriformabile, o attraverso anche atti legali, quindi leggi. Faccio un caso che proviene dal nostro ordinamento giuridico, dalla nostra storia giuridica. Nel 2004 è stata varata una legge, la numero 40, che legittima le pratiche di fecondazione artificiale. Allora erano legittime soltanto le pratiche di fecondazione artificiale di tipo omologo. 10 anni dopo il varo di questa legge, c'è una decisione, una sentenza della Corte Costituzionale, appunto nel 2014, che elimina, toglie il divieto di eterologa presente nella legge 40. Quindi dal 2014 è possibile accedere anche alle pratiche di fecondazione artificiale di tipo eterologo. All'indomani della sentenza della Corte Costituzionale, che appunto legittima anche l'eterologa, l'allora ministro della Salute italiano, Beatrice Lorenzin, insieme a altri politici, insieme a altri uomini di cultura, aveva ventilato la proposta di proporre una legge parlamentare per limitare i casi di accesso all'eterologa. Ecco, quindi questo è un caso di una proposta di una legge per limitare la portata lesiva di una sentenza giurisprudenziale. Quarto caso, ce ne sarebbero altri, ma ci fermiamo al quarto caso. Voto una legge ingiusta per legittimare in modo più restrittivo una condotta moralmente iniqua già diffusa nel consesso sociale. Quindi nei primi due casi avevamo a che fare con una legge più ingiusta che volevamo eliminare. Nel terzo caso una sentenza, in questo caso invece vado a votare una legge ingiusta per limitare e restringere alcune condotte sociali che sono già presenti nel consesso sociale. Ovviamente devo versare sempre in stato di necessità, quindi quando non c'è modo di eliminare o limitare questa condotta in altro modo. È stato il caso della legge 40 del 2004 a cui accennavo prima. I parlamentari che hanno voluto questa legge l'hanno voluta proprio per regolamentare, quindi restringere le pratiche di accesso alla fecondazione artificiale. Si diceva allora per limitare il Far West procreativo. Ci sarebbero altri casi, ma sono un po' più specifici. Molto in sintesi, il problema etico quindi è questo. È lecito votare una legge ingiusta per limitare alcuni danni? Vedremo, e questa è la tesi che devo andare a validare, devo andare a giustificare, vedremo che non è mai lecito dal punto di vista morale votare a favore di una legge ingiusta perché è un'azione malvagia. Non è mai lecito votare a favore di una legge ingiusta anche animati da buone intenzioni, anche perseguendo il fine buono di limitare i danni. Vedremo che mai si può compiere un male minore, voto a favore di una legge meno ingiusta di un'altra, per evitarne uno maggiore, esempio il varo di una legge più ingiusta. Dunque adesso andiamo a verificare e a analizzare meglio questa tesi che ho enunciato. Una tesi che poi dopo dovrò andare a giustificare e a validare. La tesi è divisa sostanzialmente in 3 punti. ripeto sostanzialmente quello che avete già sentito. La tesi è questa: non è mai moralmente lecito proporre, votare o dare in qualsiasi modo appoggio formale ad una legge ingiusta, anche perseguendo il fine eticamente lecito di limitare i danni, quindi ad esempio evitare la promulgazione di una futura legge più ingiusta, ed anche stretti da necessità. Stretti da necessità, lo ripeto, non si può che per evitare questa futura legge più ingiusta votare una legge meno ingiusta. Quindi non è mai lecito votare una legge ingiusta per limitare i danni. Lecito il fine di riduzione dei danni? Certo che è lecito, ma occorre che l'atto attraverso cui si ottiene questo fine di limitazione dei danni sia esso stesso lecito. Vedremo che la riduzione dei danni è fine remoto, è fine secondo, il voto alla legge ingiusta è fine prossimo. Ricordo quello che viene usualmente indicato come le tre fonti della moralità. Io preferisco indicarle invece come i tre criteri di azione morale, cioè il fine prossimo, che è quello che costituisce l'oggetto, la natura, l'identità morale di un'azione; il fine secondo, il fine remoto, che è il fine ulteriore a cui si orienta la natura dell'azione; e le circostanze. Ecco, in questa tripartizione evitare e limitare i danni si pone come fine secondo, non come fine prossimo. Però adesso approfondiamo. Ora dobbiamo validare, giustificare, dare la prova della validità di questa tesi, cioè che non è mai permesso votare una legge ingiusta. Vi sono alcune condotte, secondo la prospettiva del diritto naturale, del giusnaturalismo classico, secondo la prospettiva del personalismo ontologicamente e metafisicamente fondato, vi sono alcune azioni che costituiscono azioni intrinsecamente malvagie, i cosiddetti mala in sé, o i doveri negativi assoluti, come l'aborto, la fecondazione artificiale, l'eutanasia, la clonazione umana, tantissime altre. Ora, una norma che legittimasse queste condotte sarebbe essa stessa una legge intrinsecamente malvagia. Per quale motivo? Non solo perché una tale legge permetterebbe queste pratiche, quindi non solo per gli effetti, cioè si usa di questa legge per compiere il male, quindi non solo perché la legge sarebbe strumentale a compiere poi gli aborti, l'eutanasia, per accedere a pratiche di fecondazione artificiale. Non soltanto per questi motivi, ma perché a monte, ed è lo snodo concettuale su cui insisteremo moltissimo, perché a monte votare a favore di una legge ingiusta significherebbe legittimazione della condotta immorale, significherebbe votare a favore approvazione di questa legittimazione, e quindi significherebbe approvazione della legittimazione dal punto di vista giuridico, e quindi significherebbe approvazione dal punto di vista morale. Ma io non posso mai approvare il male. Specifichiamo meglio questo punto. Queste leggi, in buona sostanza, dicono in norme positive l'oggetto malvagio scelto dal singolo quando vuole abortire, quando chiede l'eutanasia, quando ricorre a pratiche di fecondazione artificiale. Cioè, queste leggi fanno proprio in senso giuridico la coloritura morale della condotta da disciplinare. Ne ricevono la specie morale, potremmo dire così, proprio perché riproducono, legittimando, non vietando ovviamente, legittimando la condotta immorale. E tale coloritura morale in queste leggi permane al di là dell'intenzione del soggetto di votare a favore perché vuole limitare il danno. Ma tu comunque, parlamentare, voti a favore e quindi approvi il contenuto di questa legge, e laddove c'è ad esempio legittimazione dell'aborto, tu approvi la legittimazione dell'aborto. Scendiamo sempre più nel dettaglio. Io ripeterò un po' gli stessi concetti, ma in realtà vado sempre più nell'analitico. Volere l'azione materiale, pensiamo all'azione materiale di premere un tasto che significa approvazione, oppure l'azione materiale di alzare una mano. per dire sì, sono a favore, oppure di tracciare una X nella casella sono a favore della legittimazione, dell'approvazione di questa legge. Ecco, volere l'azione materiale, premere questo tasto, alzare la mano, significa in un'aula di Parlamento approvare. Cioè c'è una circostanza che dà valore morale univoco e oggettivo a quell'azione morale, a quell'azione materiale. Cioè quell'azione materiale calata in quel contesto significa solo una cosa: approvazione giuridica e quindi approvazione morale. Convenzionalmente, e questa è la circostanza, si è deciso che dal punto di vista giuridico premere quel pulsante, alzare quella mano, significa approvare. E, ripeto, l'approvazione giuridica ha un valore anche morale, perché io la posso giudicare dal punto di vista morale, e approvare giuridicamente l'aborto significa approvare moralmente l'aborto. E questo non può essere dato. Quindi è l'azione stessa del votare, degli effetti successivi, cioè che la legge venga usata o meno, l'azione stessa che è riprovevole, non è valida sul piano morale. Quindi, prendendo un'altra prospettiva, esprimendoci in altri termini, come il singolo fa suo l'oggetto malvagio aborto, fecondazione artificiale, eutanasia, quando ricorre a queste pratiche, anche volendo per fini buoni, il parlamentare fa suo l'oggetto malvagio aborto e fecondazione artificiale quando vota a favore di una norma che legittima queste pratiche. Quindi in questo senso la legge esprime sempre un contenuto valoriale, perché essa disciplina alcune volontà e le volontà possono essere sempre sottoposte al giudizio morale. Allora la legge si presenta come una entità giuridica volitiva, quindi come un oggetto morale contenuto in norme. Quindi, semplificando ancora di più, come una scatola con dentro la parola bene o male. Il voto a favore di tali leggi ingiuste è atto malvagio perché questa azione di votare il suo oggetto, il suo fine prossimo, coincide è l'approvazione dell'ingiustizia della legge, ossia la legittimazione dell'ingiustizia. Quindi oggetto del voto è il finis operis della legge, già cristallizzato nei suoi profili morali e quindi non mutevole, che non può essere mutato perché è scritto e oggettivato nella legge. Quindi, ripeto, il voto a favore corrisponde alla volontà di produrre l'effetto materiale approvazione della norma, che comporta a sua volta la legittimazione della condotta. Quindi io, ad esempio, voto a favore di una legge che legittima l'aborto fino al 90° giorno al fine di evitare una legge che invece permette l'aborto sempre, però in questo caso io comunque approvo l'aborto fino al 90° giorno, ma dal punto di vista morale è rilevante quello che io approvo l'aborto. Quindi, così come chi vuole l'effetto materiale morte di una persona innocente, concreto l'oggetto morale illecito assassino. Quindi votare a favore significa in senso tecnico-giuridico approvare. Questo è il significato giuridico oggettivo e quindi anche morale. Approvare significa voler produrre certi effetti giuridici e se questi effetti ricercati, quindi l'approvazione di una certa condotta, sono contrari alla legge naturale, così come l'effetto morte di persona innocente nell'omicidio è contrario alla legge naturale, ne consegue che il voto a favore è moralmente non accettabile. Ancor più in sintesi, approvare vuol dire che X è un bene, ma se agli occhi della legge naturale X è un male, non posso in nessun modo approvarlo, anche se l'approvazione mi promette futuri utilità straordinarie. Ma io non posso compiere il male per fin di bene. Quindi, se approvare la legittimazione di un male morale è esso stesso un male, mai, come abbiamo visto, si può compiere il male per un fine buono, come ad esempio impedire il varo di una legge più ingiusta. Quindi non posso scegliere un male minore per evitarne uno maggiore. Riguardo questa tesi si possono sollevare varie obiezioni che io ho cercato di indagare poi nel libro, nella monografia. Ne indico una adesso molto, molto in sintesi, che è forse quella più fondamentale, può essere quella più radicale, anche quella che può magari ricomprenderne altre. Indico adesso, esplicito questa obiezione riguardo alla tesi che ho appena enunciato. L'obiezione suona così. L'atto materiale del votare, l'atto naturalistico meccanico del votare, quindi premere un pulsante, alzare la mano, mettere una X in una certa casella, è atto eticamente neutro, ovvio, perché parliamo di azione materiale. Quindi l'atto di pigiare il pulsante è atto eticamente neutro. Assume una connotazione morale o positiva o negativa se il votante persegue rispettivamente una finalità buona o una finalità malvagia. E questo siamo nell'ABC della morale. Pensate, l'atto di incisione, quindi l'atto materiale di incisione della pelle di una persona, è un atto moralmente lecito o moralmente illecito? Dipende dal fine prossimo che informa questo atto materiale. Se io incido la pelle di una persona al fine di curarla, perché la sto operando un'operazione chirurgica, l'atto di per sé stesso è un atto terapeutico e quindi è un atto moralmente lecito. Se io incido la pelle di una persona perseguendo il fine di ucciderlo, ed è una persona innocente, allora in questo caso perseguo un fine malvagio. Nel primo caso la natura dell'atto sarà una natura terapeutica, in questo caso la natura dell'atto sarà assassinio. La stessa cosa si riporta nell'atto del pigiare un pulsante. Quell'atto materiale può essere informato da fini differenti. E quindi io posso alzare la mano e informare quell'atto materiale del fine buono di limitare i danni, ossia ad esempio impedire il varo di una legge più ingiusta, oppure dal fine malvagio approvazione della legge ingiusta. Quindi in buona sostanza, questa obiezione ci dice: pigiare il pulsante può essere orientato a diversi fini. Un fine buono è quello della limitazione del danno, un fine malvagio è quello invece di approvazione del contenuto della legge malvagia. Risposta. In realtà chi compie quell'atto materiale di votare a favore di una legge ingiusta approva sempre la sua ingiustizia. Come dicevo prima, quell'atto materiale calato in quelle circostanze acquisisce un significato univoco dal punto di vista morale. Quindi la condizione in cui è calato l'atto materiale scelto può definire il contenuto morale dell'oggetto dell'atto. Qui rimando alla lezione tomista, cioè Tommaso d'Aquino indicava alcune circostanze, diverse ovviamente per gli atti, che possono incidere sulla natura dell'atto. Sono circostanze, lui diceva, non accidentali, ma circostanze essenziali, che quindi possono andare a costituire l'identità dell'azione, il suo oggetto, la sua natura. Vi faccio un esempio molto, molto veloce. Provocare la morte di alcuni batteri per fini sperimentali concreta un oggetto buono, sperimentazione. Provocare la morte di una persona innocente per fini sperimentali concreta un oggetto malvagio, assassinio, volto a un fine secondo buono, cioè la sperimentazione. Quindi potremmo dire che la volontà di provocare la morte, effetto materiale, assume una propria precisa coloritura morale dalle circostanze. Quali sono circostanze? Che io ho a che fare nella sperimentazione con i batteri o con persone innocenti. Questa è una circostanza scriminante, è una circostanza che mi fa cambiare quello stesso atto materiale in un atto moralmente lecito e moralmente illecito. Così accade anche per l'azione materiale del votare, e vado a chiudere in questo ultimo minuto. Qui abbiamo una circostanza che è scriminante, che ci fa dire che quell'atto materiale non si può che intendere dal punto di vista morale come approvazione morale. La circostanza è quella già ricordata prima. C'è una convenzione linguistica giuridica che assegna all'azione materiale di votare a favore il significato giuridico prima di tutto di approvazione, che poi ovviamente diventa anche significato morale, perché io posso giudicare l'approvazione giuridica. L'approvazione quindi diventa significato morale di approvazione. Poi ovviamente per comprendere se il votare a favore, quindi l'approvazione morale, è buona o malvagia, io devo andare a leggere il contenuto della legge. Quindi per capire se l'approvazione è buona o malvagia dovrò verificare il contenuto della legge. Benissimo, il mio tempo è qui terminato e vi ringrazio per l'attenzione e l'ascolto.
Grazie per questa relazione molto profonda e fedelissima alla tradizione morale cattolica e il cui tema è molto attuale non soltanto in Italia ma in tutto il mondo occidentale, compresa anche l'Ungheria. Le ringrazio di nuovo. Adesso io potevo cambiare lingua, cioè devo parlare inglese. Now I have to change the language because the next lecture will be already in English. Our next speaker is Professor Peter Lautner. The title of his lecture is Aristotle, Natural Justice. Please, Professor Lautner. Microphone captured back.
Oh, sorry. So thank you very much. I'm trying to share the screen to get you to the text. Here you are. Well, okay. Thank you very much for the invitation. I'm honored. So let's get it started. So Aristotle's account of justice is, in the Nicomacheanetics book 5, is complex. He makes many distinctions. First of all, he distinguishes universal from particular justice, saying that the former is associated with what is lawful and the latter with what is equal or fair. The former is also characterized as complete virtue in relation to another person, that is, as an exercise of all virtues towards other people, whereas the latter is a particular virtue and contrasted with graspingness, the drive to get more than appropriate. Within particular justice, he also distinguishes between distributive and corrective justice. It is here that the doctrine of justice as a mean state has been exposed in full. Finally, at least for present purposes, we reach the distinction between natural and conventional justice. The distinction is also important, for it gives rise to the notion of equity. Aristotle's argument is short, but the main lines may be clear enough. The crucial claim at the beginning of chapter 7 is that natural justice has the same force everywhere and doesn't depend on whether we endorse it or not. However, the thesis has been formulated in a context indicating that the scope of natural justice is limited. It is part of political justice and differs from the other part of political justice, which is called conventional, or sometimes is translated as legal justice. I prefer conventional because nomos does not only mean law, but also habits and certain practices, constant practices. Therefore, if we want to have a clear notion of, political justice seems to be the main or genuine type of justice, for, according to the general definition, I quote, "The just man is the one who is in conformity with the law and favoring equality or fairness," end of quote. Which implies that the notion of justice is somehow connected to the notions of lawfulness and equality or fairness alike. The primary manifestation of justice, then, is in the sphere of politics, broadly speaking, that is, in the sphere of civic activities. This is all the more understandable, for unlike Plato, Aristotle conceives of justice as a primarily interpersonal virtue. He says that political justice is justice without qualification, which may mean that it is considered the general type of justice. As a political animal by nature, man can only flourish in the context of polis, the highest form of human association, and therefore the general character of human virtues, or excellences, can prevail in such environment only. For law intends to determine interpersonal relationships, justice must be related to laws. In an ideal state, such as Aristotle's politeia, they actually coincide. Another important consequence of the classification is that natural justice is not prior to political justice. It is a part of it, and therefore there is no natural justice that could be conceived of as a pre-political phenomenon or pre-civic phenomenon. As a matter of fact, if you take a look at chapter 11 of Metaphysics Book 5, which is on the different senses of priority, we might get the impression that their relation is just the opposite. On the basis of what Aristotle says there, genera are thought to be prior to species because a certain species implies a certain genus, but not conversely. Human implies animal necessarily, whereas animal does not imply human necessarily. If the relation between political justice and natural justice is a relation between genus and species, natural justice is the posterior element. In order to get a clear picture, we should examine the priority relation between genus and species more closely and see whether the relation between political and natural justice fits into this scheme. I cannot venture to do this now. The question I shall be concentrating on has a more limited range. It concerns the description of natural justice and its relation to conventional justice. The thesis I argue for is twofold. It says, on the one hand, that conventional justice seems to depend on natural justice, and the dependence is mereological, involving a whole-to-part relationship. And on the other hand, that natural justice is variable because the laws in nature themselves are also variable in a sense. So let me start with the issue of relationship. In order to explain the difference between natural and conventional justice, one may assume that natural justice relates to laws that reflect natural arrangement and contrast strikingly with laws that are made by agreement. It is a matter of agreement whether I'm just referring to Aristotle's example. So it's a matter of agreement whether the sacrifice would be of a goat, not two sheep, or to give a modern example, we need a law prescribing which side of the road to drive on, but it doesn't really matter which side is chosen. If you want to determine the relation between the two kinds of justice, it seems that we are faced with two options. Either we think that natural and conventional justice constitute two kinds of political justice that are independent from one another, or that natural justice has a priority over conventional justice, which implies that conventional justice draws on natural justice. Aristotle's division might give us the impression that natural and conventional justice are independent subspecies of political justice, but a closer look at the exposition reveals the reason why it might not be the case. So, conventional justice is described first as, I quote, what in the beginning makes no difference whether enacted or not, but when enacted does make a difference, end of quote. It shows, I suspect, that conventional justice has two faces or levels, separated by the moment of enactment. Moreover, we also read that it encapsulates laws that are laid down to meet particular cases, such as the sacrifice to be made to the Spartan king Brasidas. The reference to the king suggests that conventional justice here is a justice made for a particular case and possibly derived from some general principle. On the other hand, the former description is based on the distinction between the state of justice before enactment and the state of being enacted. This is the distinction between the first and the second level of conventional justice. So the second level is characterized quite clearly. It contains the particular manifestations of conventional justice. Why does Aristotle say, however, that there is no difference in the beginning, only in the state of being enacted? One possible answer is that there is a general justice law which is executed in different ways. To take two examples, sacrifice must be made, but it can be either of a goat or 2 sheep. Or, again, this is Aristotle's example, ransom has to be paid for a captive, but the exact amount may vary from place to place. This general law may be the framework within which particular laws or particular kind of conventional justice are formulated. However, we do not have to say that the first level of conventional justice is to be identified as a kind of written law. It may be constituted by well-entrenched habits or practices as well. It remains to examine how the first level of conventional justice relates to natural justice. We can start with the statement that natural justice has the same force everywhere. In contemporary legal language, as you know it from the orator Demosthenes, the term dunamis refers to the scope or validity of the law, implying the possibility of enforcement. It is a general justice that entails a certain indeterminacy. The first level of conventional justice also has a kind of generality. Therefore, ransom must be paid for prisoners of war, but the exact amount varies depending on the circumstances. From this point of view, natural justice and the first level of conventional justice are very much the same. At least, the text does not allude to any explicit difference between them. It is likely, then, that natural justice encompasses conventional justice. But how does natural justice work? If it is natural, by this very name, its working must resemble the way natural laws in general work. One may claim that as nature is prior to sheer convention, respect for social laws, the basis of political justice, can be expected only if they are neither arbitrary inventions nor reflecting the interests of a particular social group only. If, however, there is a kind of social law which is rooted in nature, then it has to resemble other types of natural law. If this is the case, then, due to the assumption that natural laws are eternal, social laws of this kind also must be eternal. In Aristotle's times, some people, possibly sophists, they are not named, so we don't know really, taught that all kinds of justice belong to conventional justice. There is no such thing as natural justice, since justice in general is liable to change. By contrast, if there were natural justice, it would be immutable. Just as the fire burns upwards here in Greece and in Persia all the time, so too natural justice is supposed to be always the same for every region. Whereas what is by nature is immutable and has the same force everywhere, they, these sophists, see things related to justice in change. As a consequence, these sophists separate justice from nature, and by denying the possibility of natural justice, they confine justice to the realm of sheer convention. Their views represent a fairly strong version of the contrast between convention and nature. This is the nomospecies distinction. Aristotle deviates from their views, for he says that although in our world there are things that are by nature, for sure, everything is capable of being changed. He rejects the conventionalist premise that natural processes are governed by invariable necessities. It doesn't mean, however, that his rejection of conventionalism involves that the distinction between natural and conventional, i.e. legal, justice would lose its meaning. We have to bear in mind only that it is not variability that forms the dividing line between the two kinds. Unfortunately, Aristotle is much clearer in dissociating himself from the conventionalists than in explaining the difference, the precise difference, between natural and conventional justice so conceived. He says it is plain which justice is natural and which is conventional. Some commentators excuse this shorthand explanation by pointing out that Aristotle, just like Plato, by the way, has no patience with conventionalism, both of them thinking it is blatantly wrong. At any rate, he elucidates the difference with analogies. First, the right hand is superior by nature, and yet it is possible that everyone should become such that they use both hands equally well. He also adds that just arrangements based on agreement and advantage are like units of measurement. I quote, they, I mean these units, they are not everywhere of equal size, but larger when people buy and smaller when they sell, end of quote. The analogies suggest slightly different approaches. The first, with the hand, suggests that there is a superior element that can be supplemented on occasions. There is a possibility that we can use both hands with equal success, although the right hand is the more natural for use. The second is a general expectation. There must be some measure, which can be met in different ways, depending on the situation, whether I'm selling or buying. Despite the difference, however, we have to see that in both cases, natural justice is involved in conventional justice. In the first case as a genus, and in the second as an ingredient of a new compound, using not only the right hand, which is superior by nature, but the left as well. It provides us with a chance of introducing mereological explanations. No, I haven't found any sign in Aristotle of a discussion of the relation exemplified by the right hand, but there is ample evidence for his analysis of the genus-species relation. It is a mereological relation. In chapter 25 of Metaphysics Book 5, we read that, I quote, "The results of any non-quantitative division of a form are also called its portions or parts." That's why people assert that forms or species are portions of their genus. Later on, we also read that parts of the definition can be regarded in a certain way as parts of the thing defined, and because the definition of a species must include a reference to the genus. Well, man is a rational animal, that animal is the genus. The genus can be called part of the species, excuse me. Because, however, this kind of relation is a logical relation based on the analysis of definition, we may leave it out of consideration because the relation we are discussing is not formulated in terms of definition. From this point of view, then, conventional justice is part of natural justice. They are not independent from one another. They are not independent subsets of political justice. So let us turn to the character of natural justice. It is changeable because nature itself is subject to change. In what sense is natural justice subject to change? If we stick to the analogy with nature, there are two claims to be made. One is weaker, the other is stronger. The weaker claim that, in the weaker claim, the emphasis is on the particular decisions and actions that may vary, but are subsumed under immutable and universal laws. The stronger claim, however, does not allow for universal laws either. It insists not only that just decisions and actions, the manifestations of justice as a virtue, are different depending on the particular situations, but also that the standards by which they are characterized as just are not universal. To shore up the stronger claim, we can refer to Aristotle's description of the laws in nature. In Physics, Book 2, Chapter 8, he claims that things that are due to nature occur as they do always, or for the most part. As nature has two realms, the region of celestial bodies and the sublunar world, and the motions of celestial bodies, are completely regular, we can characterize them as occurring always in the same way. By contrast, the sublunar world, our world, does not allow for such a strict regularity. As a consequence, the laws here are not universal in the strict sense, for they must leave room for exceptions. They hold only for the most part and cannot refer to necessity. Exceptions may be various in kind. They are best discussed in the biological works. It is not only the explanation of animal behavior that has to accommodate exceptions, but of the structure of animal bodies as well. Although Aristotle often associates things occurring for the most part with what comes about by nature, we find passages where some of these exceptions are considered contrary to nature and therefore they cannot be called natural. Aristotle gives us an example in his work on the generation of animals. I quote, "For the monstrosity belongs to the class of things contrary to nature. Not any and every kind of nature, but nature taken as what holds for the most part. Nothing can happen contrary to nature considered as eternal and necessary, but only in those cases where things generally happen in a certain way, but may also happen in another way." End of quote. The reason why they are contrary to nature is that monsters, such as cows with two heads, for instance, are dysfunctional. Other exceptions, however, are perfectly natural. For instance, in most animals, he says, the liver is provided with a gallbladder, but the latter is absent in some. It doesn't mean that animals without gallbladder on the liver are incapable of living. They just do it in another way. In Aristotle's view, the characteristic of the subject matter determines the matter of science as well. It implies that some kind of congruence holds between the exactness or inexactness of the accounts and the nature of the subject matter. Because human behavior belongs to the events in the sublunary world, it denies strict regularity. It applies to the exemplary, i.e. virtuous human behavior as well. Consequently, the sciences dealing with human affairs, ethics, politics, and economy is the science of household, cannot aspire to full accuracy either. In the first book of Nicomachean Ethics, we read that in ethics and in politics, we cannot expect mathematical exactness. Another well-known consequence is that right human behavior cannot consist in following rules. Just like Plato, Aristotle rejects the view that virtuous behavior is nothing but following established rules. In their views, ethics is full of generalizations which are undermined by acknowledged counterexamples. If then natural justice can be expressed in terms of laws, just because these laws are natural, it cannot be universal. It does not apply all the times. With all this having in mind, we can return to the notion of natural justice. If things in sublunary nature are subject to laws that are flexible themselves, and natural justice works like natural law, then natural justice also admits variety. Different manifestations or formulations of this kind of justice meet the standard of being natural only if they are functional. And I cannot discuss it now, but Aristotle has a long story in politics on what functional may mean in this context, when he's discussing, for instance, the different forms of constitutions, good forms or bad forms. In the world of living beings, monsters are called unnatural because they are dysfunctional. Furthermore, it seems that natural justice contains conventional justice. The rejection of conventionalism carries the weight, since as a consequence, scenarios such as the one we know from Sophocles' Antigone are gone. There is no natural versus conventional justice. In subsuming conventional justice under natural justice, Aristotle makes it impossible that the one oppose the other. This is his answer to the old age problem of nomos contra physis. However, it doesn't rule out a possible conflict between various proposals for conventional justice or just action. The reasons for this may be familiar by now. First, there can be several forms of conventional justice understood as particular exercises of a generic pattern. Second, just as natural laws admit slight variety, natural justice may not be uniform either. And this is, thank you very much for your patience and attention. Thanks.
Thank you very much for this very interesting lecture, which gives us a very important contribution to understand better Aristotle, whose importance for the natural lawyers is evident. Now, the next speaker of our session will be Professor Mátyás Szalai. The title of his lecture is The Drama of Hunting. Is Professor Szalai.
Well, thank you very much, dear Professor, dear Chairman. Could I, well, I would like to share my slides, but...
oh, sorry, yeah, sorry.
Thank you.
I have to, sorry. How to get rid of, oh, well, I'll be back.
I see, okay. Now maybe, just a second, please bear with me. Too many things open here. Share screen, okay. Which one is it? This one, okay. Well, thank you. First of all, I'm sorry that I couldn't attend all the lectures, but those ones I could attend, I have learned a lot. So many thanks for those who took the trouble of organizing this interesting morning. Now, I'm going to talk about a minor issue, but I hope that is not completely irrelevant for the topic of natural law. So that you see a little bit, I lay my cards on the table so that you see my motivation. I was very much dissatisfied with most of what I had to learn on animal rights. And so my suggestion is to look at hunting, because I think that might illuminate a little bit how natural law is related to animal rights by offering you a phenomenological analysis that doesn't commit the major mistake of considering the natural without the supernatural. And so that you understand a little bit my background, I was very much influenced by, I live in Spain, so by José Ortega y Gasset, and by the phenomenological tradition, especially the notion of drama by Joseph Tischner. I will keep it short so that I could listen to the next professor talking about Reinach, who is one of my heroes. So let's see, these are the 8 points I have here. I have a short introduction, then I would look at the questionable presuppositions, those ones I was annoyed with. And the third point is offering you a rather philosophical approach to hunting, even though I'm not a hunter myself, but I have some experience through my family, where everybody is a hunter but me. Then the fourth point is to suggest a revised order of proceeding, not looking at hunting within the context of animal rights, but rather looking at the question of animal rights through the drama of hunting. And the fifth point would be, entering into the field of phenomenology to underline and stress the dramatic character of hunting, then looking at certain aspects. Then point 7 is dramatically experiencing nature's subordination through hunting. And the 8th point is considering the gaze of the animal, so that kind of the culmination of what the encounter with nature might look like. Let me give you kind of 4 ideas to introduce you into the topic. So in what follows, I would like to argue that in spite of the radical transformation in cultural views on hunting, which is from a virtuous activity, it has turned to be a despicable activity. It has an essential aspect that has not changed. A certain kind of hunting allows for the utmost dramatic and personal encounter with animal nature. I would like to stress the word a certain kind of hunting, so that not all kinds of huntings, but I'm going to be as precise as I could to give you a real example, because the whole structure of what I'm going to present you is fits under the category an argument by an example. So the example should be precise. Well, the significance of this encounter is critical for any further consideration, be it legislative, economic, or cultural, and can only be fully expressed and analyzed by philosophy, I suggest. Rather than arguing for a definitive position concerning animal rights, I would like to demonstrate in a phenomenological way that hunting possesses an irreducible dramatic character that should be fully taken into account with respect to the law. I'm not going to argue for or against hunting. I just want to say what hunting is, so that if anybody looks at it, may not look at it in a reduced perspective or a reductive perspective. So in order to do so, however, first, some space needs to be made for philosophical reflections regarding the mainstream discourse concerning hunting and animal rights. Secondly, the types of hunting must be clarified. And thirdly, I will offer a phenomenological, rather than an esbozo, just a draft for a phenomenological account of the personal encounter with wild animals. Now, let me just briefly state what is the question here. So, do animals have a more specific, or more specifically, wild animals, do they have rights? The debate is centered thus on the status of animals. And since animals are more than objects or property, but are not yet persons or subjects of the law, they fit into neither of these legal categories. So that's where the whole discussion is is about, basically. It is argued that in order to protect the animals from abuse, a new category must be formulated according to which some rights can be attributed to them. Thus, there is a legislative problem that must be resolved by either expanding the concept of property or by modifying what is the subject of the law. These are the two proposals I was facing when studying this topic. So let me make a more general comment without arguing for its validity, just by being honest with you about how I feel about this question. Postmodern Anglo-Saxon society in particular has a tendency to transform any issue of contemporary social relevance into a juridical problem. This must be overcome, or at least complemented by a more philosophical approach that rediscovers and restores the original context of the given phenomena, allowing to be seen in its complexity. For me, such a hermeneutical restoration of what the complexity of the phenomena is the original way of its givenness certainly does entail its religious relevance. So, looking at hunting as a ritual is of utmost importance here. Without the aid of philosophy, juridical reflections might mask important distinctions. And let me add here humbly that without the aid of poetry or art as well. Because they characterize the original givenness of the phenomena. So thus restoring philosophically the concept of hunting as a complex cultural activity by exploring the conscious experience of those who engaged in certain types of hunting with the right disposition can even and must must correct legislative short-sightedness. Let me underline the word here, with the right disposition. I am very eager to, instead of a general, defense of hunting and being an advocate for hunting, I am certainly an advocate of the right disposition of somebody who is a real hunter rather than a man with a rifle. So the philosophical approach to hunting that was important even for Plato, some methodological observations. Now, look, this is very general, and I will keep it short, even concerning what it is written there. There are basically 2 points. I think we have to relearn how to approach the issue contemplatively. That's what Plato suggests. So what is the act of contemplation? I'm not going to explain here this, but it certainly explains, well, it entails as a consequence an openness towards different philosophical methods and both analytic philosophy, hermeneutical consideration, and the phenomenological description has its place in what happens after contemplating the issue. Well, I've already clarified this a little bit that, what is the revised order? You can see the slideshow. Well, the point I would like to make here is hunting appears to be a paradigmatic case of encountering wild animal nature. That's what I would argue for. Why is it so? Mainly because it offers us not just knowing what animal nature is, but it also helps us to understand what is the human, what is the place of a human person within the cosmos, within nature, and within what I would like to call the theodramatic complexity. The third point here I would like to make is that, already mentioned before, the specific attitude that leads to a dramatic encounter. Here, the general rule is of Thomas Aquinas that if you want to see what is the essence of a horse, don't look at the donkey. So, bad examples of huntings are not going to help us. We have to get the right example of the best example we can come up with of hunting that helps us to see what this dramatic encounter is about. Now, looking at traditional accounts of how the activity of hunting is categorized, concerning with the attitude it is carried out, concerning the prey, concerning the who is doing it and the way it is done, etc., etc., I came up with like 6 aspects. So I'm arguing that it should be big game hunting. It should be a one-to-one encounter. So rather than, many people hunting many animals, then it certainly should be a real and not a virtuous activity, a real encounter. So internet hunting and canned hunting is rather excluded. That it should apply. I didn't even know that there is internet hunting. That's like a horrendous idea, and even a more horrendous practice, I guess. Well, it certainly should follow the ethical rules of fair chase, and concerning the purpose, it is it has. I would argue for a combination of the 3, and I'm rather arguing for a quiet hunting than the noisy hunting that has been condemned by the church. Some things that I also didn't know before studying this issue. Okay, some words about the fair chase. Look, given the short time, why don't we just focus on what is underlined? There is, okay, I have to read you now the first paragraph. So fair chase, however, involves more than the hunter's realization that would be ethically wrong to misuse the natural and technical advantage. So there's a limitation of the hunter's activity. It also requires self-knowledge, teaching self-respect through the recognition that unethical behavior would dishonor the hunter. The specific virtues of temperance and accountability concern more than just the relation to one's own self and to the particular animal. It is based on an attitude towards nature in general. I would go even further, and I would say the hunter's attitude is not just towards nature, but towards nature as it is given by the supernatural. So there is even a divine human relationship. You know, the gift of nature is exemplified in the prey. So that's why hunting could be a virtuous activity, or was regarded for centuries as a virtuous activity. Now, so let me just state blankly that fair chase hunting is certainly not centered on the act of killing the animal. That's a secondary thing, but rather on a series of actions that express care for the individual animal, the environment, and the complex balance between them and other animal population. It requires thoughtful contemplation of the equilibrium within nature, as well as the relationship between nature and culture. It is in this sense that the document confirms hunting should be guided by the hierarchy of ethics. Well, that's not a very clear term, but I think we do understand that it is certainly not about killing the animals. It's a very complex activity that entails an incredible amount of judgment in which the human person responds to nature by realizing his own complex responsibility. Okay, let me just read you the last one. So in this sense, we can understand that the second part of the admonition that I would rephrase like this: the dramatic relationship between the predator and the prey that becomes evident through the encounter reveals something fundamental about man's place in the world and his dramatic responsibility to preserve and cultivate nature. So I think that's probably the most important point that might help us, that hunting is a far more complex activity, and opposed to how it is interpreted and in most of the papers written on animal rights, regardless of which positions they claim, you know, but they're expanding the concept of the animal or subject or property. Okay, now let me say something about the three purposes that hunting has. Well, the three are, substantial, therapeutic, and sport. Now, I do have a comment to each of it, if you bear with me. So, authentic hunting is therapeutic and serves the subsistence of humans. There can certainly be another legitimate purpose of hunting beyond nutrition, but just that there is a clear limitation of how and much a hunter can eat, there must be a limits to other needs as well. So hunting is essentially about these limits. It is a virtuous practice of limiting one's needs to a measure of what nature provides us with. This point is very well made by Ortega y Gasset. So he says that the hunter is the one who regards and is aware of the limits that should he himself put to himself in order to be called a hunter. So if the hunter entirely leaves grounds of subsistence hunting, he steps outside of nature and participates in its soulless exploitation. To some extent, subsistence hunting is based on an attitude that was greatly admired by the Stoics, observing the laws of nature and understanding how those rules are prescriptions for a good, balanced, and virtuous life. That's why young people were instructed by their fathers to learn how to limit and balance themselves and live a virtuous life. Those who want to abolish hunting are often not aware of how it is based on a participatory closeness to nature. It is in this sense that hunting may indeed offer a concrete praxis to save us from the illusion that dealing with the natural world is a question of looking at data and inferring technically and reciting the ecological systems. I had a hard time to understand those arguments that stated that hunting is not anymore necessary for nutrition, so that's why we just should get rid of this barbaric practice, because we can now fabricate meat, even artificial meat. So what is the point of hunting? And well, it seems to me that by abolishing hunting, they also abolish the dramatic encounter with nature concerning nutrition. As if we could just intervene into nature without the dramatic consequences and the dramatic responsibility of the human person. I think this is an illusion, and hunting helps to get rid of this illusion. So, maybe we can look now of what I mean by the very dramatic aspects of hunting. My claim is that the above characterized way of hunting offers a highly dramatic encounter between animal and man. There are some aspects that allow us to talk about a drama. It entails a serious conflict that endangers the life of at least one of the participants, either the animal or the hunter. So it is, we can talk about drama because it's a question of life and death. So secondly, it involves a morally relevant and meaningful free decision. There is no drama if there are no free decisions. The decisions are made certainly at the moment of, shooting or not shooting. I've heard some stories where somebody got so amazed by the natural phenomena, let's say some deers appearing in a beautiful setting, that his decision was not shooting, and that was the very moment that made him to become a hunter, because he understood that shooting is secondary. The real question is meeting what nature offers you, and being able to make a judgment, and being even forced by your human nature to make a judgment on what is offered as a gracious gift. Now, the third point is it has a great representative power concerning the relationship and the nature of each entity involved. We can talk about the drama because hunting is always more than it is. It has a symbolic force. From an external point of view, the events embody the complex interrelationship between man, nature, and the divine. As argued above, big game hunting best incorporates these characteristics. There are several essential aspects of hunting that express the symbolic surplus meaning that comes to the fore through an authentic encounter. Now, I try to break it down, what I mean by this surplus meaning that often is not taken into account in these academic papers on animal rights. So one is that the animal's capacity to expose nature as it was created, as opposed to a civilized and cultivated nature. The second point is the significant cultural way of relating to nature that is always present in hunting. And the third point is hunting, ruling nature, and taking care of the fragile equilibrium, as well as the actual killing of the animals, has a spiritual and moral implications that need to be made explicit, socially regulated, and symbolically thematized. Through its dramatic power, quiet hunting provides us with a fundamental insight concerning what it means to participate in nature. What has not sufficiently been thematized in these papers was the necessary ritual aspects of hunting. that responds to this surplus meaning of, you know, what is spiritually and morally questioned and well, even thematized by hunting. Well, the second point is, you know, this second slide is about if you analyze the process of hunting, that is a complex process, that there are different actions to it that need to be attended separately. One is that the hunter enters nature by renouncing control over the environment and by following the animal into its world, where anything can happen. Ortega y Gasset is very explicit on this point. You know, culture meets nature, and culture renounces certain benefits in order to follow nature. The hunter becomes one with nature. It just disguises himself so that he can come closer to the animal. It's not just physically coming closer, but closer to the original givenness of what is nature. That's already hunting. It's not the moment where you shoot. That becomes, you know, most of the hunters in 95% of the hunting activity are fascinated by this event. But I think all children were fascinated by following quietly somebody, and you know, so that's response to human desire to see what is the very basis of our supernatural nature, right? So the hunter's approach to nature entails a paradox, the simplifying of which would destroy the meaning of hunting by reducing it to a mere leisure activity, which I would be completely opposed to. On the contrary, authentic hunting is about the dramatic scenification of a complex relation, allowing all essential aspects to become an essential and potentially transformative experience, for it offers and requires certain catharsis. That's what is really fascinating about hunting, is the cathartic part. That means nature can really transform us by questioning us as cultivated people, but also as you know, part of the redeemed creatures, ultimately speaking. Moreover, as those whose redemption has to be extended to animal nature, to be more explicit here. Okay, the third point is, in the complex experience of hunting, man is empathically testing the limits of unifications with the animal. That has certain limits, obviously. He has to get into their mindset, has to hear and see what the prey is hearing and seeing. This challenges man and is counterbalanced by the dramatic encounter with the animal when man emerges from nature as the creature called to care for it. The experience of hunting thus offers a realization of man's unique status in nature. In contrast to any other animal, the fulfillment of human nature requires overcoming nature. That's what's happening there when the hunter that is disguised in nature, disguised as an animal, even as part of nature, in the moment of the encounter has to emerge from nature and has to reveal himself as the one who is called to be responsible for nature, thereby transcending himself by realizing that man is made to a loving care for all life, fallen nature, and everything that there is. Well, I don't want to abuse your patience, but maybe we can dwell a little bit on this point. Sorry. There is a change of perspective that is proper to the experience of hunting. The hunter's readiness to leave their comforts behind and go out into the wilderness is a counterculture expression, a sign of their openness to seeing human nature in another light. This change of perspective invites us to an existential redefinition through encountering nature. By this traumatic experience comes at a high price, the consideration of taking the life of an animal. Today, it is widely recognized that our horrendous waste culture does serious harm to nature and the environment, but does not offer you this change of perspective. So my point here is, you know, if you look at hunting and do not merely, and let me say clearly, stupidly concentrate on the act of killing the animal, but of the complexity of hunting, there is something that is absolutely and utterly philosophical. That's why, you know, Plato used this example as for an analogy of how we encounter the good. We go out of culture in order to get into the wilderness, where something, the encounter happens that questions us and redefines our own nature. It seems to me that only a deep Christian understanding and understanding of redemption can truly help us to live this drama properly. You know, only if we know how we are loved and how the animal is loved, can we take really care of the sacrifice that is presented in front of us and can say a yes to it because it was affirmed as an offer for us. Well, that goes certainly further than just you know, mere philosophical or phenomenological analysis of what is there. But I guess it helps to understand how complex hunting might be. Now, let me finish this with a couple of thoughts on the gaze of the animals that is dying. That is the real drama, no? To accept that's what has been given and to take it away, even coercively. So the dramatic encounter of man and the prey reaches its climax in the revelation of the given animal's nature in its innocent gaze when seen through the crosshairs. What does it tell us? That moment has been beautifully described by Széchenyi Zsigmond, no? At several places. You know, what does it take to look at the eyes of the animal that is killed? Animals may not feel sorrow for their own death, but they do require the highest degree of empathy we can have towards them. That certainly has its limits. Now, they do not ask for mercy, yet they do express a compelling innocence. Their appeal contains no reproach, for they cannot morally judge actions, but they offer a resistance, a struggling for life. It is deeply significant that life is precious to them, their innocent gaze expressing the mystery of life on earth. It is not so self-serving, but highly communicative to one who can understand it. What is vanishing becomes the center of attention in the dying animal's swan song. Do they accuse us? Undoubtedly, there is a question addressed to humans. I don't think it's an accusation. I think it's a question. Why should I die? What have you done to make it necessary? Man is left alone in a long silence, wondering whether the killing of the animals was justified. As Ortega y Gasset rightly argues, hunting is more about this dramatic puzzlement than anything. A man must enter it in order to discover his own role in nature, a praxis that we necessarily have to make. It seems to me to become human. We cannot live in the illusion, and that's what the nutrition industry and all the protectors of animal rights want to by eliminating this drama. That's a necessary drama. It is in this sudden lifeless silence that the animal tells us about who we are and are not yet those who are called to reign in the created universe, even though we are not prepared to do it without higher assistance. It is the silence in which one has to assume the consequence of the original sin. Hunting offers us an opportunity to experience man's fall as a rupture with the purity of nature. Some can bear this tension between our lost innocence and our vocation to care for creation. Ultimately speaking, I think that only on a religious ground, hunting can be really saved, because the real question why we can still hunt and why it is ultimately speaking legitimate is because we are entitled to live this drama. Some can understand that animals point us towards our task to reign over nature by never forgetting our own culpability. Some understand that hunting is primordially a drama in which every single time the animal is sacrificed, the hunter is presented with a question he cannot answer by himself. When will nature be redeemed? So to put it short, I think hunting is a way of a dramatic and absolutely personal way of incorporating and involving the animal reigns into the human, divine human drama. And that's why it has certain relevance. Thank you for your attention.
Thank you very much for this very, very interesting lecture. The topic of which was a very original and very good choice, I think. It offers a lot of new topics for natural law, and at the same time, it's a very good new approach to the problem of the actual debate on human rights and so on. Now, next speaker is Professor Nadia El-Beheiri. The title of her lecture is Social Acts According to Adolf Reinach, the Roman Law of Procedure. Is Professor El-Beheiri.
Thank you very much for the introduction, and I'm really happy about this interest on phenomenology. I will shortly share my screen with you, which I will hopefully succeed. Okay, I think I succeeded. So my presentation of this afternoon is about procedure in Roman law, very ancient procedure in Roman law, and the social act theory of Adolf Reinach. It's also considered to be a little bit a report of our research, of our work we are doing in the Roman law department. We heard already in this morning Professor Erdődy. In this moment, we are centered a little bit on phenomenology, trying to translate, let's say, the work of Adolf Reinach, a priori foundations of civil law, into Hungarian. It's a joint project with colleagues from the Faculty of Philosophy and also with our colleagues from the Department of Languages. So we are centering very much on this point. In 2002, it's the background of my presentation. A German professor of Roman law and the translator of the Institutions of Gaius, Ulrich Manthe, stated that the very ancient procedure of Roman law of the legis actionis can be understood from a modern point of view as a procedure based on an explicitly performative speech act. Manthe refers in his essay expressly to the work of the American scholar John Austin, who in his very famous book, How to Do Things with Words, is considered to be the founder of the so-called speech act theory. It was interesting that it was also mentioned the other day by Professor Volga Chaba. A performative speech act, according to Austin, is a sentence which at the time being uttered performs, acts upon the word, does something. Mante indicates that with the sentence used in the Legis Actio Sacramento in rem, hunc ego hominem ex iure quiritio meum esse aior, I declare that this man is my by quiritory right, can be considered as such a performative speech act. We will come back to this later. So we can put here the second slide about the Legis Actio Sacramento in rem. We are going to center on this issue and Adolf Reinach. Of course, in this group, Adolf Reinach is well known. Unfortunately, he died in the First World War. He can be described as one of the most important disciples, I think, of the founder of phenomenological, considered as a leading scholar of the realistic branch of phenomenological thinking. To this branch, as it also might be well known, belongs also Edith Stein. We heard a little bit an approach in this morning from Professor Erledi, Dietrich von Hildebrand, and this is our point, why, this is our starting point, why we started to center a little bit on the phenomenological idea, because Dietrich von Hildebrand was the teacher par excellence, we might say, of Wolfgang Waldstein, one of the scholars we work deeply, connected very much with it in our department on Roman law. He is also a doctor honoris causa of our faculty. We have to mention, of course, Roman Ingarden, Hedwig Konrad Martius, and I think from animal rights she is important. And now my topic today is a very narrow one, we can say, and it's to connect speech acts or the social acts of Adolf Reinach in contrast somehow to the idea of speech act theory of Ulrich Mante with the Legis Actio Sacramento in rem. Very briefly, some problems, some questions too, I pointed out in connection with the Legis Actio Sacramento in rem. It's the very ancient procedure in Roman law. We find it also in the 12 tables, and scholars dealing with the Legis Actio Sacramento in rem base their analysis on three primary sources, Cicero, Gaius, and Gellius. Mainly, the three texts show numerous parallels, but also contain differences. The descriptions are each from a different perspective. Cicero acts as an advocate in a trial. In this very specific trial, his aim is ridicule the technical aspects of the procedure. Gaius approaches the text from a systematic point of view, we can say from the point of view of the teacher. And Gellius, most probably, approaches the procedure from the point of view of a judge. He was an experienced judge. The secondary literature on the subject is extremely wide-ranging, and still there are many questions which had not been conclusively discerned. It is well known also that also Janusz Sliński, the first dean of our faculty, worked on this topic, and among others published an essay in the Savigny Zeitschrift in 1809. In this context, he had a very deep exchange, personal exchange also with Max Kasa. A recent attempt to grasp the character of the Legis Actio Sacramento in rem was made by Francesco Giglio in the Savigny Zeitschrift of 2018. So I am going in my contribution today to mention two of the questions which can be considered still open to discussion, and then in a second part I'm going to go through the procedure based on the social act theory of Reinach. The first issue, which has been emphasized especially by Max Kasa, consists in the fact that based on the account of the introductory part of the Legis Actio Sacramento in rem given by Gaius, the two parties in the procedure before the praetor declare that the thing is theirs. There's no reference to any unlawful behavior before the procedure and no indication that the assertion made before the magistrate may be unlawful. CASA places, therefore, the two parties on the same level. The starting point, which has been designated as tout à fait singulier by Lévy-Bruhl already in 1916. Based on his initial assumption, CASA develops his theory about the relative ownership. According to CASA, the assertion meum esse aio applied not to an absolute right, the action aimed only on an allocation of an object of one of the two parties. The decision of the judge did not express a view on the nature of the allocation or on the right claimed by the winning party. This approach has been criticized by numerous authors. The Italian scholar De Francisci rejected the idea of a relative ownership. Meum esse ex iure quiritium was necessarily an absolute claim. Also, Alan Watson refuses the idea of symmetrical positions between the two parties. The Hungarian scholar Diósdi Győr argued that the relativity of the judicial decision did not amount to the relativity of substantial law, only from a procedural point of view. In view of these objections, CASA revised his position and proposed a split ownership instead of a relative ownership. The original acquisition granted absolutely protected positions, so CASA. The derivative acquisitions, ways of acquisitions, granted relative positions. We can point out also that the most original contribution of Janusz Sliński is that he stated, based on the account of Gallius, that after the opening ceremony, the magistrate made the first decision and allocated the thing to one of the two parties. In accordance with CASA, the judge at the end, when he did not have clear evidence for one of the two parties, decided in favor of the possessor. But the possessing, according to Sliński, was granted out of his imperium by the magistrate. This very short review shows that the nature of the legis actio sacramento in rem is very much connected with the nature of ownership. Adolf Reinach, from a phenomenological perspective, distinguished sharply between possession and ownership. According to Reinach, possession is the relation of power in which a person can stand to a thing. This possession is not a right, but a factual relation. On the other hand, ownership or property is an ultimate irreducible relation which cannot be further resolved into elements. This relationship is particularly a strong relationship between a person and a thing. The relationship is the owner of a thing has the absolute right to deal in any way he likes with the thing which belongs to him. Reinach expressly mentions, and I think that's a very interesting point, only one case in which ownership arises without doubt. The case when a person produces things of materials that have not been owned before. As the legis actio sacramento is essentially about protecting relations of power, we might conclude that the aim of the action is not so much to protect ownership in modern sense of the term, but to protect possession by the early community. And now let's look a little bit on the social acts. What is a social act? An act, according to Reinach, we can say, or we tried to grasp the idea of social act, it's communication through external signs that creates laws, rights, and obligations. The main characteristics of social acts are intentionality, which is one of the main issues also of phenomenological thinking. That means that every act of grasping ontological realities is always related to an object. The second point is spontaneity. which refers to the inner acting of the subject. Reinach underlines that spontaneous acts have, in addition to their intentionality, also their spontaneity. Two further requirements of social acts are an other directness and the need of being clear. He mentions some social acts, which is the assertion, commanding, requesting, questioning, yielding, submitting, enactment. It's very interesting that he mentions those social acts on different parts of his book. Assertion, commanding, requesting, questioning. So the first three elements are mentioned in the introductory part about social acts. The last second ones, which I mentioned here, are discussed by Reinach in connection with the positive law. So in another part of the book, submitting, enactment, creation. Now, let's have a look at how we imagine the idea about the legis actio sacramento in rem. I made some slides in connection so that we can imagine a little bit what we are dealing with. We are starting the first party, and this is an interesting point. Here is standing, making an intentional act and making an assertion saying it's mine. Meum esse io. And the second party here, it's enough if the second party hears it, receives the assertion. It's not necessary that the second party here accepts the assertion made. It's enough, and we can say the intentionality is referring to the Sachverhalt, meum est, to the Sachverhalt, which is also a key issue of the philosophy of Reinach and the state of affairs, they can say in English. Meum est. So the first party declares that this animal we chose, or I choose an ox, which is also related by the sources and discussed deeply by Janusz Linsky. He's saying it's mine. It's enough for the assertion that the second party receives it and like somehow says, I hear it. If we center now on the social act of commanding or requesting, which Reinach says that the two social acts are very close one to each other, and perhaps they many times we can distinguish them only through specific words which are used, or also by the tone of the voice. So commanding, requesting, there are social acts which are really going in the same direction. And here we feel perhaps the essence of social acts, which is not a mere communication theory. Because if I say it is mine, and we say the second point, give it back, it won't be enough. If the other person, if the other party says, I hear it, yes, okay, I heard it. But an action is required. And this action is required by the very nature of the social act. And this is a point which Reinach underlines. By the very nature of the social act, it is required that the other parties react somehow. The same thing we can see in the questioning. If somebody say, I don't know to whom it belongs to, do you know to whom it belongs to? Like putting a question, we have also the same elements, and we realize also that it's not enough to say, I hear it, but we need an answer. The question, by its very nature, from an ontological point of view, requires an answer. Yes, commanding Reinach, this is also an interesting point. If it's not heard, if the other party does not receive the assertion, Reinach compares it to a spear which falls to the ground without hitting the target. It's a very nice image, I think. So it must be heard, but in questioning, commanding, and requesting, we need an action or we need an answer from the other party. If we focus now on the legis actio sacramento in rem, we have here the text, which is also very close to the words used in emancipatio. We say, hunc ego hominem ex jure quiritium meum esse aio. I declare the slave to belong to me on account of in accordance with Quiritan right. Ulrich Mante, we mentioned before, he made a big effort to demonstrate that in ancient Roman language, in ancient Latin language, this point of aio comes from saying, from speak, and not so much together with the word ago. Normally in Latin language, sometimes in Latin language, aio here is also compared to ago, and we see like in a later time, these two verbs somehow found together. No, ago we can say we put in motion, move, lead, drive, and conduct. But he makes a deep effort from a linguistic point of view to demonstrate that in very early times it meant exclusively saying ago. And so he comes, Amante comes to the conclusion that this is a declarative speech act by which the speaker makes an assertion about the fact that does not yet exist in order to bring it into existence by that speech act. A key difference between the speech act theory and the theory of social acts is that the speech acts are based, from the point of view of pragmatic, is a conventional, and the successful performance of a speech act depends on positive law. In contrast to that, social acts, the social acts idea of Reinach refers to essential structures. According to Ulrich Mante, the question if the declarative act will be successful depends on the provisions of positive law. According to the social act theory of Reinach, the issue is more complex. The assertion is not between creating a situation, but it serves the interaction between the persons in order to decide between the contradictory assertion. It was necessary that all parties involved performed further social acts inherent to their situation within the Roman community. And so I tried to visualize also this point. When we have the same situation here, when we see, okay, there is an assertion made, which is meum est. Now we have a difference to the slide before. Now the assertion is made before the praetor, and we have also witnesses. A very important point was, or a difficult point, let's say, was who is going to make the opening assertion? The one who is the possessor, the one who has the animal, or the other one? If we say that the first party, who is not in possession of the animal in our case, has to make the opening position, it would mean that the second party has to put evidence on it, which is completely a different perspective to modern point of view, that the defendant has, the possessor, let's say, has to put the evidence for his argument and not the claimant. And this is one of the difficult points, but I think this is also one point we can find somehow a solution through the idea of social acts. Because the two parties in front of the praetor on the one side, also with witnesses, make exactly the same assertion. They're saying this animal is mine. This is like the opening ceremony. In order to come to a result, we need more interaction. As it is well known, the ancient procedure was split in two parts. We had the one in jure and the second one apud jure judicem before the praetor. And then after this opening assertion, we say that the praetor says, both of you release your hold upon the thing. And this, from the idea of social act, is a command from the part of the praetor. And the praetor is able to make this command out of the imperium, which was granted to him. A special element introduced by Janusz Liński was that on this point, there is a forecast on the part of the praetor. The praetor shall provisionally assign the thing to one of the two parties. This is an interesting point made by Janusz Liński. He said, okay, the praetor makes a first decision. We can also somehow, from some point of view, compare it with the interdict we use in later times, also in connection with the more developed procedure for later times. So we have here a forecast on the part of the praetor, and he gives the thing, he assigns the thing to one party or another. And then on this point, the praetor transfers out of his imperium again his power to the judge. The parties we have here, and here I didn't put the witnesses, but we need them also. The parties we have here, they submit themselves, which is again a specific social act. And at the end, we have an enactment from the part of the judge, which originates a new legal situation. And I think this is also an interesting point. Here we see all the parties involved in the procedure, all the parties making specific acts of specific social acts, and at the end, the judge creates something new. And the judge has this power, which was transferred by the praetor, and we can say, at least theoretically, by the Roman community. And then he makes an enactment creating a new legal situation. And here I tried to be cautious in the formulation. Didn't say if he creates now necessarily ownership, probably not. He creates somehow possession, a form of possession which was legally protected by the Roman community. And so I think the idea of Reinach, of the social acts of Reinach, they fit very much with the Roman law approach. I made the second part also comparing it with the procedure of the praetor, where they don't speak in first person, but we have already the formulae which are used. But still, we recognized in them the idea of the interacting of the parties, and also the interacting of the different people involved in the procedure. And like a last sentence, we see also, we have here, theoretically at least, we have the praetor, which is the magistrate. We have witnesses somehow, which are present also like representing the people of Rome. And then we have also the judge, which is in one way or another representing, former times, in early times, he was a member of the Senate. And so we have within this procedure the three organs we had in early Roman law. And so I think this is an interesting point, is an interesting approach. In the beginning, I said it's somehow a research report, because on the second point might be to look closely on Roman law literature on this point and to compare it with the idea of social acts. So thank you very much for your attention. And I think I'm also open to discussion, or it might be a good idea or a good possibility to have some discussion on the topic. So thank you again for the attention, and thank you also for the organizers and also the chairman for this meeting. Thank you.
Zoli, fel kéne kapcsolni a mikrofon.
Thank you very much for this lecture. It was very interesting to hear about this surprising coincidence between Austin and Reinach, between the speech act theory and social act theory. And I could even increase the surprise, saying that even in Thomism, namely in Maritain, there are some germs of speech act theory, but I don't want to abuse your passions. So my role as a chair is finished now, and I give back the presidency to Professor Frivaldsky. János, maybe he wants to say some closing remarks. Please, János, if you want.
No, thanks, but I think that after all of the entire day, today and yesterday, in order to sum up, I would like to say a great thanks for all of you. And I think that just having this overview through these lectures and presentation, I can say that the natural thinking not just alive, but still vigorous and prospering and flourishing, and I'm very pleased of it. Thank you very much for all of us, for all of you.
Thank you. Goodbye.
Goodbye, and thank you for everybody for the lectures.
Thank you.
Thank you.
Thank you.